Item 1 for motion.
Yes, opinion is at which page?
Your Lordship. Your Lordship, I am the proprietor of Saraihat Security Services. Lordship. Accordingly, I provided security services to the medical authority or such other institution, Lordship, in and around Guwahati. But accordingly, I specially provided security services to the respondent number 6, Lordship, that is offshore infrastructure.
But is your prayer within the scope of habeas corpus?
Yes, Lordship. Only because of that, Lordship, the respondent number 6 has made transaction to me, Lordship. That is
It may be
29.
police action, but it can't be a habeas corpus.
Your Lordship, in this regard, Lordship, the police authority has taken me, Lordship, pick up me from my residence, Lordship, and restrain me. For
Are
a
you
overnight
are you
more
are
than
you
12
are you still under detention? You're not under detention.
At that point of time, Lordship, I was
So it may
detained
be
for a
police.
overnight, Lordship. For a overnight,
See,
Lordship, wherein
You
police
see, we
has
can
ambushed
just tell you, but we can't. We are not. We can't convince you. Is it a case of police action or it is a case of habeas corpus? What is the rate of habeas corpus? Please tell us.
Your Lordship, habeas corpus is that, Your Lordship, when any illegality done by the police authority and violation of the fundamental right of the petitioner, Article 22(1), Lordship, then habeas corpus will be issued by the appropriate court. So this.
Please check out with the Constitution of India and our laws on the habeas corpus and tell us. We'll take it up after some time. Convince us that this is when a person is not within the, not under detention, then it's still habeas corpus.
Lordship, I was detained, Lordship, but when Lordship, at the time, Lordship, at the time of detention, Lordship, at around 1 a.m., Lordship, my son has shouting his voice, Lordship, why I was detained, Lordship, without showing the ground of arrest, without furnish the information, Lordship. Then, Lordship, the police has, Lordship, medically examined, Lordship. And Lordship, wherein compelled me to make an agreement. And after making an agreement, Lordship, the police has released me from my police station, from the police station, Dispur police station, Lordship.
Okay, we'll pass orders in chambers. Yes, you have to say anything.
No, I'll take instruction.
We'll pass orders in chambers.
Your Lordship.
Yes, item 2.
Yes. The Lordship order last 29/5, last part of the law. Planet pending council estimator shall obtain instructions to the status of the two persons.
Okay.
Yes. We don't have any information till today, my friend.
Well, they're in Kukrajar holding camp. They're detained in Kukrajar holding camp.
Holding people.
But then, what do you call? The petitioners are projecting that there is a Supreme Court order of bail.
Yes.
And they have complied with the order of bail.
To that effect, my lord, we'll file affidavit, my lord, because there are issues, my lord, where they have violated the conditions of the bail, my lord. So they have been detained, my lord. Because they
are being detained where?
My lord, at Kukrajar holding camp.
Kukrajar holding camp.
Yes.
First time we are here.
They will not be deported till the next date of listing.
No issue, my lord, but There is currently at Kukurajal, holding center at Kukurajal.
Building center at Kukrajal.
It is newly constructed or it is earlier it is existing.
Right, it's there.
There is much central detention camp is there, Mathia mine.
No, that is.
No, that we should know actually, sir. We are visiting again and again Mathia Central the detention. This is only one detention camp.
No,
Mine.
the government may have separate holding center, my lord. It
No,
is
but
not-
ideally the citizens have a right to be informed. Even if he is a foreigner, declared foreigner,
No,
but still his family members has a right to be informed.
There are some people who have been brought back, mine. Your worship might have known
Well,
from.
there are two or three things, maybe there are many reasons for
Yeah.
that. Some people may be very poor,
Yes.
so as not to afford any legal assistance. So,
Nobody in a
I think-
position to meet them, my lord. Even those who are in detention camp, they are not in a position to begin the ukalat, my lord. They are not allowing. To some cases we came to know, my lord.
no, for that, you already know the law.
Yes, that is already we have. advice, my lord.
Anybody can file it.
That
If
that's
it's a-
already advice, my lord. But what is the going
Habeas
on? What
corpus.
I am saying.
No.
Yeah, no. I have so many. At least 10% came to me, my lord.
No, let-
No,
My lord,
I
something,
don't-
some
I don't want
rule of law, my lord,
submission
we are-
this, my lord, whatever will submit.
You do whatever you like, and we keep. We are
No,
there,
you-
my lord.
We'll
you
submit
have
an
a point.
affidavit.
You made a point.
Yes.
Heard Mr. H.R.A. Chaudhary Lanet.
Holding camp of a hill.
Holding center. Holding center.
International.
এইটো হেৰি হ'ল, terrorist school.
Other customers. Let them say and keep and come back to me. No, this is one goal and I can go now. That's about it, I think. The general law is a socratic condition validation.
বেলেগ বেলেগ স্যার সবরই কন্ডিশন বেলেগ আপনার ক্ষেত্রে তো বেলেগ
আমার তো দিকে condition violate করেছে নাকি
আপনার কন্ডিশন বেলেগ
এই law।
অ্যাপিয়ার করেন না
এতে কোনো warranty issue করবো?
না গাইডলাইন তো স্পেসিফিক করা আছে তেওঁলোকে এভরি উইকস অ্যাপিয়ার করে
কোনো কারণে মানে
দ্যাট হ্যাজ টু বি কমিউনিকেটেড তাদের এটা ডেট মনে ঠিক আছে
একটু লইলো বসে মতো তাও বাস ভালো লাগবে হয়তো শিক্ষিত তো কি বলবো যেগুলো আমি শিখিয়ে দিবে
No, sir, no, my lord, may give a short date, my lord, we'll file affidavit and the issue may be heard, no issue. Otherwise allegations, my lord, counter allegations. This is
at least you inform us
instead of-
where we have been
instead of, my
put.
lord, going to this.
Yeah.
Yes.
Okay.
Yes. I have seen it, my lord.
So the annual hologram.
Yes, ma'am.
Punto, based on the.
Seen it, I have seen it. Yes. Let us see, my lord, whether they have completed. That's why, my lord. That's why my information as on now is, my lord, they have, they are in Ukrazer Center, holding center, that much. Further information, my lord. Yes. No, Other, yes, because, my lord, the other issues I have not, my lord, discussed. Only the issue where about the petitioners, my lord, the petitioners' brothers. That must.
Heard Mr. H.R. Chaudhary, the senior counsel, assisted by Mr. A.W. Aman, learned counsel for the petitioner. Also heard Mr. R.K.D. Chaudhary, learned DSGI, for respondent number 1. Mr. B. Gogoi, learned standing counsel for respondent numbers 2, 3, and 4.
Your condition.
And Mr. J. Payang, learned standing counsel for respondent numbers 5, 6, and 7. Next paragraph. Pursuant to order dated 29/5/2025, the learned standing counsel for the FT matters has submitted that as per instructions received by him, the petitioner,
Brothers,
Uncles, man.
uncle.
the petitioner's uncle,
Yes, uncles. Your lordship,
Two uncle- two
paragraph 2, my lord. Oh, sorry,
namely
paragraph 4.
Mohammed MD, Mohammed Abu ABU, next word is Bakar, BAKKAR, and Akbar Ali, who have been taken into custody, are presently lodged at a holding camp, Kokrajhar. In Kokrajhar, where it is?
Kukrazer, my lord, it is in Kukrazer.
BTAD, man.
No, Kokrajhar, we don't know. Kokrajhar is a town, Kokrajhar is a district.
Only that much is information is given, my lord, holding it
But then tell
Kukrazer,
us,
center at Kukrazer. It is in Kukrazer town, my lord.
no, I understand, but to find a needle in a haystack, you can give us something, you can tell us something more.
Yes, I can give the information, but your lordship may dictate it.
Okay,
I'll-
okay. Because Kokrajhar is a town, is also a
Yes,
district.
which place I'll exactly
Huh.
which place.
Just give a gap. Huh?
Yes.
It will be filled up. That's what it's- Stop. On such disclosure we made, the court is inclined to grant to the petitioner visitation right to the set to detain persons on the strength of a certified copy of this order. Most of the person who is in the official who is in custody of the said Mr. Muhammad Abu Bakar and Akbar Ali, on production of a certified copy of this order shall permit visitation right to the petitioner. Next para. At this juncture, the court is inclined to extract the copy of order dated 10/5/2019 passed by the Supreme Court of India in WP within bracket C, bracket close number 1045 of 2018. This is the order. Next paragraph. As notice has already been issued by order dated 29/5/2025. The respondents in the Home Department, respondents number 2 to 7, shall file an affidavit regarding the apprehending and the detaining of the petitioners in the holding camp at Kokrajhar. At least one day prior to the next date of district. Next paragraph list on, give a date after 10 days.
Sixteen.
16,
16 is Monday,
Monday.
16/6/2025. This order, I put a flag mark.
And one thing can be done to SP, madam, because they do not know who, to whom they have to go, madam. So it is.
No, whoever is the in charge.
Madam,
Because again, if the SP, supposing the SP is in a place different from where they are holding,
right.
again, your one day will be gone. So whoever is in charge,
In charge of the complex. Holding center.
holding center, who is whoever.
Polished.
I said, I've used the word official.
Somebody must
camp.
be there, madam.
Ah.
Hold on.
Yes, item 3.
May I please, Lordship?
Yes, Mr. Bhuyan.
Lordship, in this case, I tell the opinion on basically.
Which
the
page is the opinion?
Opinion 107, start from 107, Lordship. Basically, the evidence has not discussed at all, Lordship.
107.
107 from 107, Lordship.
This is September opinion, Mrs. Verma. Heard Mr. S. Bhayal and counsel for the petitioner. Respondents are there. Opinion is at page 107. Opinion dated 24/9/2024. Passed by so and so. In FT case number so and so, police reference IMDT case number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Prayer for bail is opposed by the London Standing Council for the FT matters. Considering the projection, 10 days time to take bail, rupees 5,000 to the satisfaction of
SP border no.
SP border Nagaon.
It is clear, my friend.
Item 4.
Make resolution. My opinion is page 61.
Tell this later date bill. Record only the date of office. You to date to pay your comment.
Page 61, my lord.
Date to pay.
Order date is 22/7/24.
22/7/24. Okay. So you are granting bail.
Yes, Lord.
Same with Mr. H.R. Ahmed for the petitioner. Page 61 is the opinion dated 22/7/2024. Passed by so and so in FT case number so and so, IMDT case number so and so. Same amount of bail, 5,000 to the satisfaction of
Deputy Commissioner of Police B, City Guwahati.
City Guwahati. Deputy Commissioner of Police B, City Guwahati.
Obliged, my lord.
Item 5.
Bringing date.
Yes,
Page 37, my lord, 25/6/24, my lord.
35,
37, my lord, 37.
37. Okay.
25/6/24.
6:24. So just on time. Okay. Mr. A.W. Aman for the petitioner. Opinion at page 37,
My lord,
25/6/2024. So and so in FT case number so and so, IMDT case number so and so. Bail to the satisfaction of
Kamrup Metro, my lord.
Superintendent of Police Border, City Guwahati. No, it's
Commissioner of Deputy Commissioner of
Deputy Commissioner of Police B, City
Border.
Guwahati.
Border law.
Okay.
Item 6.
Lord, this is impugned order is page number 17, my lord. This is an ex-parte order.
Oh, 21.
My lord, may I read the next page? This was passed during the COVID, my lord. May I read the next page, my lord? Page number 18. May I read, my lord? Accordingly,
Let us examine the records because notice was served on your brother.
because, my lord, this person is not my brother, actually. I have made a statement. Abdullah is not my brother. Also, the entire process, my lord, was during COVID. In between, they stopped the hearing. they should have issued me a notice again, my lord.
No,
They did
Lordship,
not.
there is nothing
There's
of
nothing
that
like
sort
that.
in law, Lordship.
There's nothing like
Issuing
that.
of notice twice, thrice, Lordship, after it has been served.
But it was not served on my brother, my lord. I have made a
We
statement.
don't know, have the records first. Mr. A.W. Ahmad, Land Counsel for the petition. The respondents are there. Ex-parte opinion dated 12/3/2021. Passed by so-and-so in FT case number so-and-so, R case number, R I think would be reference, R case number 830 so-and-so.
Is FT case number 194 corresponding to our case number, my lord?
Which the petitioner was declared to be a foreigner, post 25/3/1971 stream. Notice returnable on, give a date after vacation, give a date.
No. Can it be before vacation, my lord? A date may be fixed, considering the circumstances, my lord.
It will not come.
"73-year-old woman, my lord.
73.
My lord, I am protected, my lord. I will be grateful, my lord.
So make it 23, 6/2025. Extra copies within 2 days. The requisition for records be sent to the following email address of the learned tribunal, with liberty to the said learned tribunal to send us scanned copy of the records if records cannot be physically sent. First of all, the tribunal is at liberty to take the assistance of the Office of the Superintendent of Police, Border Borpeta, for availing the scanning facilities for the records. And the prayer for bail shall be considered on receipt of records. First of all. It is, the prayer for bail shall be considered on receipt of records. So how it is provided that the how considering the projection that the petition is aged 73 years, it is provided that the petitioner, namely so and so, shall not be deported out of the country without order of the court.
Grateful, my lord.
Item 7 or motion.
Please, Your Worship. My lord, in giving the opinion at page 64
Date to put your plan.
and
Page number
page 64, opinion dated,
64.
yes, Your Worship. 22/10/2020.
So you don't have friends here.
They're also busy and some
That is
in late lordships.
too bad.
It will like it, yeah.
You should offer few friends tea and coffee in the canteen. They'll stand by you.
24.
Okay. Mr. M.I. Hussain, counsel for the petitioner. All the respondents are there. Opinion at page 64, dated 22/10/2024. Passed by so and so in FT case number so and so, police reference case number so and so, declaring her to be foreigner post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Prayer for bail is opposed by the landlord standing counsel for FT matters. Considering the projection made in bail of rupees 5,000. 10 days time to take bail to the satisfaction of
SP border Dubai,
SP Border Dubai.
TP of life.
Supplementary item for motion 24 with 25.
আমার তো 25 to 9 আহিছিলে সেইদিনা আগত আহি গৈছে জানো দাদা 25 to দিয়ক না অল্প এলসি Ex-parte order না না হেতুটো মানে Ex-parte নেকি দুটা 18
Lordship would kindly take up item 25 first. This is regarding the husband. 24 is the wife. Now, what has happened is on an earlier occasion, your Lordship has directed that the matter will be heard on maintainability or on the ground of delay. Now, in 2018, the opinion was passed, and in 2020, we approached this court. And I filed that particular writ petition with both husband and wife together as petitioners. Then a separate reference was again issued over the wife, for which I withdrew that particular petition and I filed it in 2025. Now, in that particular reference of the wife, she is again contesting before the FT Morigaon. Now, before I proceed, Your Lordship, yesterday I was provided with an opinion of two brothers of the petitioner in item number 25. This opinion has been passed in the month of January 2025, Your Lordship. Here, the same court has held them as foreigners who have entered India between 66 and 71. If Your Lordship would allow me to place this by way of an additional affidavit, then perhaps I can argue for an order of remanding the matter till evidence stage over these two petitioners. Perhaps I can exhibit the same exhibits which my brothers have done so.
Once you'll be able to overcome the explanation for delay, then we'll be issuing notice, then you will be permitted. But you are saying
My
that
lord,
there was,
in both the writ petitions, my lord, there are no explanation with regard to delay, my lord. I admit it, my lord. The only
unless you avail an opportunity say something, otherwise.
I can place it by way of an affidavit, but my only ground will be, my lord, financially handicapped and illiterate.
No, whatever it is, but unless it is there, you risk a dismissal now.
Then I will do it within this week itself, my lord. Tomorrow or day after, I'll do it.
Huh.
If Your Lordship places it on next Friday, my lord.
Okay. On the prayer made by Mr. P. Bharadwaj, Land Counsel for the petitioner, the matter stands adjourned today. List on. You want it on Friday?
And next Friday, my lord. Not this one, the next Friday.
Next Friday is 13th,
Yes, my lord.
13/6/2025. It's the same order in item 24 also.
Highly appreciate.
Supply item 26 for motion.
কতটুকু বিচার করে আমার কাছে আছে
What has happened?
They gave us the access that we had, the facility has been given us to provide the exit permit. Now, even to apply for exit permit, I need to have a mobile number. Now, I'm in jail for 4 years.
But you can't get a mobile. You have to use what do you call the number of the police station.
No, it's as per their website that I need to have the foreigner, I myself, an Nigerian citizen, have to have an Indian mobile number to apply. Otherwise, I can't even register myself. So So that is the difficulty. And even after registering,
No, then we'll have to ask him to get instructions, whether a foreigner would be permitted to have a mobile number of the country. There's something which we can't just pass an order.
yes, Your Lordship, but the difficulty is that I have been given the certificate, emergency travel certificate. Now, their facility is that I've been in jail for 4 years. At least give us, I don't need mobile number. I just need an exit permit to go out. That's all.
You see this,
Yes.
there are certain things which we don't have an answer. Because, for example, income tax return or a GST return, they have to be filed online. And perhaps the court can't circumvent that procedure and say that it could be filed physically. So I'll be depending on Mr. Adhikari to get us information.
Yes, my lord. I have been in constant touch with FRRO Kolkata. My lord. Even today morning, I had a talk with them. My lord, I expressed the inability expressed by my friend to them also, my lord, that he's not having a mobile number, he's not having email ID. So he's facing difficulty in uploading those documents. My lord, then the officer told me that the only way it can be done is through e-module. So he has to have a mobile number. Otherwise,
But will the government of India provide a mobile number to a foreigner? You agree to it?
that cannot be done, my lord.
Then
Yeah.
you can't put a condition which can't be complied with.
Yes.
Therefore, you'll have to communicate with someone
Yes, yes.
and then tell us whether you under the government policy
Yeah.
you can permit him a temporary mobile access
Yeah.
to make an application.
Yes, my lord.
It may not be a permanent connection,
Yeah.
but the mobile connection now, the difficulty is that with mobile, you must have all what you call it, nowadays it has to be a smart mobile to get the information and those things. So you see, a person under detention, we have to consider their plight
My lord.
of how to be in jail and then be able to purchase a mobile, purchase a connection. These are things which
Another thing, my lord, Lordship, I kindly come to that instruction of 8/5/2025, my lord, which I had placed on 16/5/2025, and it is referred in your Lordship's order of 16/5 also. Lordship, I kindly come to para 2 of that instruction. My lord. It is quoted in that order of 16/5, my lord.
I don't think we have instructions. We have given it to you, I think.
That is quoted in your Lordship's order of 16/5.
Which order?
16/5/2025.
Ah, yes,
Yeah.
is there.
Lordship, I kindly come to para 2. My lord,
Para-
it is regarding that consolidated instruction that has been sent to the state government and the United Territories, my lord. In this regard, may I read, my lord? I think, my lord, they can be deported now.
Pardon me?
Para 2, my lord.
Ah, yes.
In this regard, consolidated instructions have been issued to all state government, AUT administrations, FROs regarding procedure to be followed for deportation of foreign national while Ministry of Home, so and so and so. As per para 3 of the instructions, a foreigner other than a Pakistani national can be deported by the state government, Union Territory Administration, FRRO concerned immediately on completion of the sentence court proceedings if she has a valid travel document passport. Normally here in this case, my lord, now he is having a valid travel document. He has completed his sentence, my lord. So I think, my lord, the state government, my lord, subject to correction, my lord, can deport him. And
No, but you see, so far as the government instructions are there, it is the same government who is now saying that you must have an exit permit.
yes,
So you are, what you call, this is a way of not permitting a travel. If somebody has completed his sentence, overstayed for 1400 days, and then he will have to 1400 days,
80 days, I think.
80
yes.
days, and then he has to seek everything. Then we'll have to, no way but to direct the government to provide him with an access to mobile and then do it.
And my lord, other thing which she told me over phone was even lordship passes, there's a telephone instruction, lord. Even lordship passes an order for deportation. Then what happens? The state police will escort him till the immigration point. And from immigration, alert, he'll be sent out. Because the immigration then will contact the FRROs through e-modules. But there's a system according to her, madam, the lady officer. So then it can be done. That's what she told me over phone. Ma'am. But that is not the written instruction I have.
Send it for me to learn.
That's what she told me.
No, we understand. So therefore, see, we have two alternatives. Number one, we direct the state government to provide him facilities of mobile access, so that it's the government who provides him with the mobile temporarily. Maybe a second-hand mobile, used mobile, but it should be a workable mobile provided to the petitioner. Then the Ministry of Telecommunication will not create any hurdle for a SIM card to be given to the petitioner. Third is that this the entire whatever is the protocol process for taking the petitioner from Guwahati to Calcutta shall be complied with. This is one part. Second part is we say, you see, this is something which we term it as coercive action. Now we say that once he is completed almost 1500 days in illegal custody, you provide him with a compensation of 5 lakh rupees. And then it will be the government of India who will pay it, and then you will decide with the state government what to do about the money. How will you share it? Because ultimately for illegal detention, if the state government does not take any action, state government and central government are equally liable. Now, central government has been put to notice that somebody is in illegal custody. And then also they say, do this, do that, do this, do that. So these officers will provide them with facilities, whatever they want. We give 7 days time to the Ministry of External Affairs to do the needful to have a mobile provided to the petitioner for temporary use. It may be a second hand, but it should be a workable mobile provided to him with a SIM card at the cost of the government, to which he'll apply. And 7 days time, if he can't exit.
Or yes, let him approach the SP, my lord, who is designated as FRO, physically, my lord, somebody, and my lord, have a talk with him.
No, you think over, because whatever you say will pass an order. It should be complied with.
Yes. Even that is one of the instructions I have been, my lord, given, that the petitioner's counsel or somebody else on his behalf may approach the SP concerned, because even they can issue that exit pass.
Exit.
Yes. That's what I've been told.
Superintendent of Police would be within the domain of Mr. Sharma.
Yes.
He's in Matia.
Matia detention.
Not it.
It will be border police or it will be the state superintendent of police regular?
Well, same person holding in the same person.
Okay, same person
Same
holding
person.
two
Different
designations.
designation, yes.
So please get us information at 2 o'clock, whether it is within his domain or not.
The exit permit, my lord.
Exit permit.
Exit permit. Otherwise, when the FRO, yes, the district SP is the FRO in each district, but
Pardon me?
SP concerned is FRO.
No, but here there's a
Yes.
designated FRRO at Calcutta.
Calcutta.
Yes.
So whether it can be done, I can get the instruction.
Mm.
Like whether if we can, well, definitely we can do it.
So we'll try to take it up at, if you get it by 1 o'clock,
Yes,
it's okay, otherwise at 2
I
o'clock.
will get the instruction. Before 1 o'clock, I will get the instruction.
Then we'll take it up at 1 o'clock.
Telephonic
before we
instruction.
rise.
Yes. And that, my lord, I'll get the instruction on that.
Because that instructions would be twofold. Number one, as per instructions by Mr. Adhikari, he needs to apply himself.
Yes.
For that, he would need a mobile number of his own and a mobile set also. Now, whether a temporary,
He can use somebody else's mobile number also.
no, we don't know. That's why
Yes,
you see, the problem is,
He has said.
the problem is that in a detention center,
Yes.
you're not permitted a mobile. So therefore, you are asking the court to violate the law laid down, which says that, no, you understand the implication. I'm just telling you the implication. That's why we are questioning it.
Yes,
To give a mobile to a inmate
Yeah.
is something which is not permissible under the Assam Police Manual,
yes,
jail manual, sorry. So once we say that you violate the law, we must understand the implication of the orders.
yes.
So therefore, we are asking the SP to say whether he can provide a temporary handset for the purpose of facilitating his application. Once he can do it, then he can have a what you call short tenure SIM card, which will be used and then taken away by the SP.
Whether the SP can issue the exit pass or not. Even
That
that,
must-
And that's second, this is the second part.
yes.
Okay.
At 1 PM before rising.
It be taken at 2 o'clock.
We started the APSC matters. We are in a deep quandary.
Hard to take.
You may not be here. You ask somebody to be here for you.
Yes. In fact, I asked the detention authority, detaining authority to give the every facilities to apply itself.
Huh.
Yes,
Yes,
they were ready to provide everything.
but then again, you see, the condition is
Yes.
he must have his mobile in his own name. Now, how can you permit that?
Yes, ma'am. Probably that can be that may be optional also because
We don't know. I have absolutely no idea. You just pray that after I demit my office, I go to some foreign country and get caught and then learn, get an experience and come back. More wiser. Just pray for that.
Alright. And then item number 2, my lord, the designated the center is at my lord 7th Assam Police Battalion, Sarai Kula,
Please write it down.
Yes.
Much of it.
Sarai Kula.
Okay. Anybody is here for from the chamber of Mr. H.R.A. Chaudhary? Please inform him of that the address.
7th Assam Police Battalion, Sarai Kula.
Okay, next.
Item 27.
But page 81 is on in order, Manoj.
Page
81.
80.
27 to 2025. In order.
Okay. Mr. Jiuddin and
A.K. Azad.
Oh, sorry, Mr. A.K. Azad and counsel for the petitioner. Responding, sir, the opinion is at page 81. Dated 27/2/2025. Passed by so and so in case number so and so. ERO case number so and so. For declaring the petition to be a foreigner post 25/3/1971 stream. Notice extra copies in 2 days. Call for the records. Prayer for bail is opposed by the 11th Standing Council for the FT matters. Bail of rupees 5,000 to the 10 days time to take bail to the satisfaction of
Border Gwalpara.
next.
Twenty-eight.
28. Page 73 in order. That is also 28 February 2025. 73.
same order, opinion dated 28/2/2025, page 73. Asked by so and so, FT case number so and so, FT case number so and so. Same order.
Awesome.
Twenty-nine.
Wait, this is your lordship last.
Yes. Opinion at page
Page 20, lordship.
20. 91.
Yes, lordship. He is not aware that I had made a statement, and even the son has sworn in this affidavit of this petition, and I had sent the son to get the entire order sheet that I made a statement also, but he could not trace out the records in two tribunals. In paragraph 5, I have made that statement, lordship. This is the reason once the case was assigned to me, there is a delay in filing this, even this writ petition. So he was inquiring in Foreigners Tribunal 8th Barpeta as well as 11th Sharbog.
No, it will always be in the first tribunal. It will not go to any other tribunal.
Because
except for first.
jurisdiction wise, as per the local council had stated that it might be their jurisdiction of the police station.
No, it's not jurisdiction wise. It's Mr. Payang?
Yes.
I think it will go to the first
Yes,
tribunal.
yes, yes. Well, the records of IMDTs were in the first tribunal.
But it will always be
Yes.
in the first tribunal.
So he was marked as D voter. He was not aware of this. He was marked as D voter. This is the reason he has once approached this honorable court also. That order also I have annexed, lordship.
Which page?
Page 23, lordship. I humbly beg if one chance is given, he has relevant documents to prove his citizenship.
But you see, this, come to page 21, paragraph 3, it says you have received it. Notice what duly served. You received yourself.
But what had happened with that and not, he was not aware. So I wanted to get the order sheets and all, lordship.
Petitioner was not happy with D status. He came to the High Court. High Court says that reference be made. Now reference was made. He received notice.
Well, in
it
fact,
was a-
this,
Trouble by,
And I had made a statement also.
trouble by invitation.
Lordship and made a statement also because since directly with the client, I couldn't talk. So I have, there is a communication gap also between the council.
No, maybe, but you see, there's a specific direction by the tribunal that was
Yes, Lordship,
by
that
the tribunal that notice has been duly served on him. Okay, we'll call for the records to see whether 91 records can be sent.
yes. Test of whether it is there or not. Copy করতে পারলাম।
Hmm?
Copy টা।
You call it?
Certified copy টা করে পেয়েছি বাস। এই copy টা, copy। Upper Division Assistant Foreigners Tribunal number 2, no?
91 records will be 27, 20, 4 years old.
No, there is a certified copy, my lord. It is issued by upper division, page 20, my lord. Probably it will be lying there in that book. Upper division assistant, foreigners tribunal number 2, no?
Barpeta.
Number 2.
Yes, probably this matter is
This is 2 or 11.
11.
11. 11.
Because this order also I received.
Second, mate.
Huh?
Second.
Yes. Above my lord, round,
second.
round it is second.
Second. Right, right. Rounds it is second. But then Mrs. Ghosh will have to say something more. If it is 2016, then he can't say that he is not aware.
Yes. This is
Then
certified.
you risk a
copy.
dismissal of the writ petition.
No, Lordship, I have made a statement because I could not talk to the client. So what was the delay? Why there is a delay in filing this? This is the reason I wanted to get the certified copy. So I was assigned in the month of March this year, Lordship. So this time I had filed subsequently. Reason is that I had sent the son to locate to get the certified copy of the entire order sheet. So what had happened after 2016?
2016 official paper now. Yeah.
He's an aged person, Lordship. So I humbly pray if one chance is given, he has land documents and there is no shifting, Lordship. All along in one, I have annexed the Jamabandi and all, Lordship. All along in one village, 1958, 65, Jamabandi, I have annexed, Lordship. His
Let's
father.
we call for the records first.
Yes, ma'am.
Yes, Lord.
Let the records come. What is there?
Mrs. D. Ghosh and counsel for the petitioner. Also heard so for the respondents. Next fella. Right, filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 31/7/1991, passed by the erstwhile illegal migrants within bracket determination, bracket closed tribunal, Barpeta, in page 20, in case number so and so. Ex-parte opinion. By which the petitioner was declared to be a illegal migrant. Next, giving the issue of maintainability open on the ground of delay and laches in approaching in assailing the impugn order, comma. Court is inclined to issue notice returnable on it goes after vacation.
Lordship, I humbly pray for before vacation, Lordship.
It will be very difficult for us to handle.
Because from 7/8 he is in detention, 7/8/2024.
Okay, make it 23/6/2025. Extra copies in 2 days. Next para. From the photocopy of the certified copy of the opinion dated 31/7/1991, comma, it appears that the certified copy was issued by the foreigners tribunal within bracket second, Barpeta, Stop. Accordingly, the registry shall issue an requisition for the records of the IMDT case number 36. I can't read, it's 36 or 38?
38, 38 of
38,
98.
38 of 98,
98,
38 of 98,
not 98, 91 is the opinion. It's 90, Lordship.
90, okay, 30 of 90. Which was disposed of by opinion dated 31/7/1991 from the Foreigners Tribunal, second Barpeta, at the following email address. Next, the said learned tribunal is at liberty to send a scanned copy of the records. Records cannot be physically sent. Next, to facilitate scanning and transmission to the court, comma, the said learned tribunal shall permitted use of scanning and email facility available with the Office of the Superintendent of Police, Border, Barpeta. Next, list on 23/6/2025. And before that, the prayer for bail shall be considered on receipt of records.
Lordship. Until then, he may not be deported, Lordship.
No, we can't say that. His 91 opinion is
Yes.
sitting over. Therefore, being made in the connected interrogatory application.
Lordship, legal aid counsel. As the-
What's a legal aid counsel?
Legal aid
Okay.
counsel.
Yes, legal aid counsel. Okay.
Deeply obliged.
Then Ms. Ghosh will just record something more.
Yes, Lordship.
In her submissions you had, the Learned Legal Aid Council has submitted that although the matter was assigned to her on
Of March
4/3/2025,
5.
but as she could not procure the order sheet of the case, comma, there was some delay on our part to move this application.
Deeply.
Supplementary item 30 for motion.
Other Milord, was Milord released on Milord 30/4/21. Milord having completed 2 years, Milord. Now he was picked up on 25/5, Milord. But the
Which page is the opinion?
opinion, Milord, page 16 it starts, Milord.
2018.
Milord. He's been Milord picked up Milord, on Milord, 2018, Milord, and was released on bail, Milord, that Milord, under the Supreme Court's order, Milord, page 31, having completed 2 years in the detention camp, Milord. Now he has been picked up on 25/5, Milord, thereafter his whereabouts have not been disclosed yet.
We'll just provide you with the information where is lodged. Your other prayers made in the writ petition, they can't be ordered.
At least not they should be provided information where his lodgement at this moment.
Why that much? We will be rejecting all your other prayers.
Well, deportation without following due process.
No. They will not be deported without due procedure. You can't presume that they will be deported
No,
without.
if they will not tell the whereabouts, that's because
Hmm.
nowadays till now we don't know anything about it.
Because you see, you are not entitled to that. We don't find you entitled to anything more because of the fact that you were taken into detention and then you were granted bail
Well,
by this court. But this opinion was never challenged.
this was that's true. This
So
was
that
not
has attained finality. So you can't hold the process of deportation.
my submission would be the learned tribunal has held that to be a foreigner. But whether that person is of which country origin, that has not been decided. There is no material.
Only specified territory, otherwise it will not go to foreigners tribunal.
True, but then there has to be some material to suggest that. That's
Now 2018 after 7 years is too long a period.
The tribunal's order, opinion, Lordship will find. Not an
It's
iota.
okay, but that opinion is not a challenge. We are not applying our mind on that.
But what happens, my lord, in this kind of opinion, the person becomes is rendered rather stateless rather than being a foreigner.
My lord, the state will take it. That
It is for them to
Yes.
think of
Yes.
why should I spend my we in the bench. We should spend our time on that.
But at least first of all, let them tell me where they are. Where the person is
I'll
lodged.
definitely, that information I can provide. Only one thing, my lord, I would like to inform your lordships. Because the 15/4/2020 order and the Supreme Court orders, my lord, because we have to know the facts, my lord. What happened in this order was passed for mitigated the COVID situation in that time, my lord. Whether case is pending or not, that was not the issue. My lord, if whether they have approached the High Court or Supreme Court, or, that was not the issue in these cases, my lord. They were released as there was COVID situation. Those who has completed 2 years term, this is exactly on 15/4/2020. It was in lockdown time, my lord. No person was in fact allowed, not a single person was allowed to come out from the house. In fact, I came before this honorable court only to help these people so that they can be released from the jail to avoid this COVID situation. Under such circumstances, this order was passed.
No, we understand,
You
but
know.
you see,
No, but
that's
the
why.
facts I wanted to know why this order has.
We have seen
come.
that. That's why we are saying you come to page 29.
Yes.
At page 29,
Yes.
after F, A, B, C, D, E, F.
Yes, my lord. I have seen this, my lord.
Correct.
Yes.
Now they'll show me a quarterly report.
Quarterly report. Yes.
So if your SP is not doing it,
Yes. That is also another issue, my lord. Whether doing or not, I don't know, because I have to
no, I
take
don't
the
know.
instruction.
There's there's something called Assam
My lord,
disciplinary and some act. I don't remember the full name.
my lord, why I'm saying, my lord, your lordship may kindly say page 27, para 3, my lord. This part is very important.
No,
Yes.
we've seen that. You see, unless I saw this, I would not have come to that paragraph.
Yes, my lord.
You will have to produce
No,
something.
I have seen this, my lord. I have seen this. I know this, my lord. Why I was showing, my lord, page 27, para 3. What
We
situation,
understand
my lord?
whatever
Yes.
is happening, but
Yes.
you are taking a
No.
conscious decision.
Yes, conscious decision. But only with regard to release of detainee who have been declared as foreigner under the provisions of Foreigners Act 1946, the Honorable Supreme Court by order dated so and so in writ petition number so and so to the effect that detainee awaiting their deportation, my lord. All these were awaiting for their deportation, but to mitigate the COVID situation, they were.
That's okay. You just inform
That was
them
the
for the time
The
being.
state, in fact, they have taken a stand in the affidavit when the Supreme Court that affidavit have an expert. They detail the procedure, how these deportations are done. Well,
Yep.
it is.
No, you
yes.
see, unless any legality is shown,
Madam.
it would presume that the government acts are done in accordance with law.
Well, therefore, my lord, even if they are deported, my lord, they must show, my lord, how they have been deported. My lord. It's not as if, my lord, that, my lord, it can be done just like that, my lord.
You ask one of the most what you call most human rights conscious country
Well,
who are deporting citizens.
yes, I'm right. Lordship is.
We learn from them.
My lord, but then there is a fundamental difference there, my lord. There's a fundamental difference in the, my lord, the two, my lord, situations, my lord. Well, they are the people who are being deported, my lord. There is no dispute with regard to their nationality, my lord. these people, Malad,
Here also it's not, once there is an opinion, there is no dispute.
well, the opinion, no,
Yeah.
Malad, so far the opinion is concerned, Malad, that only points to one part of the story that he has not been able to prove his citizenship, Malad. So far as the foreigners, Malad, nationality determination, that is not in the domain of the tribunal also, Malad. That is with the domain of the central government, Malad.
We don't have to spend our time there
Yes, sir.
because this is not a subject matter of challenge.
Malad, first of all, let them, Malad, say at least where these people are, Malad.
That you will get by
Yeah.
Wednesday, Friday, you will get it. Heard this time, Datta and counsel for the petitioner, as well as respondents. Next, bill.
It will be fixed on Monday, Malad.
Monday. Okay. The following prayers are made in the writ petition. Page 13, 14. Next, the counsel for the petitioner submitted that the petitioner was taken into custody on
25/5.
on 21/5/2025.
25/5, Malad.
Who's the petitioner?
The son, Malad.
Oh, okay, the father of the petitioner, namely Abdul Sheikh, ABDUL SHEIKH, has been picked up by the police on 25/5/2025, and since then his whereabouts are unknown. Full stop. Next paragraph, from the materials available in the writ petition, it appears that the petitioner is a declared foreign national by opinion dated 13/6/2018, page 16, passed by so and so and so and so. So it also appears that the father of the petitioner was detained on 30/4/2019. However, in view of orders passed during COVID period, by being order dated 15/4/2020, passed by this court in WPC within bracket Suomoto, bracket close 1 of 2020, comma, the father of the petitioner was released on bail on certain conditions. Full stop. This next paragraph, there is no material on record to show that the opinion dated 13/6/2018, referred above, has been interfered with. Full stop. Thus, the status of the petitioner, the father of the petitioner, is that he's a declared foreign national and therefore is awaiting his deportation. So under such circumstances, the petitioner is not the father of the petitioner is obviously not entitled to be released and handed over him back to the family. Full stop. Accordingly, that part of the prayer made in the writ petition stands rejected at motion stage without issuance of notice on the respondents. Next paragraph. As the petitioner projects that his father was taken into custody and his whereabouts is unknown, not known, we request the standing counsel for the FT matters to obtain information as to the place where the father of the petitioner, namely Abdul Sheikh, is presently being held, if not already deported. And if the petitioner has, the father of the petitioner has been deported, he shall provide information as to the place through which the petitioner was deported and the manner of deportation. Next para. List on Monday, 9/6/2025. Next para. The Learned Standing Counsel for the active matters is permitted to send a downloaded copy of this order to enable him to obtain information and to inform the court accordingly. List on so and so.
9/6. 9/6.
$31.
Hello. Page 76, the impilo.
নতুন কেস না?
Page number
76, man.
76.
29th March 25.
Okay. Mr. A.K. Azad and counsel for the petitioner. All the respondents are there. Page 76, opinion dated 29/3/2025, passed by so-and-so in case number FT so-and-so, ERO case number so-and-so. Notice extra copies within 2 days, call for the records. The prayer for bail is opposed by the Learned Standing Counsel for the FT matters. Bail of rupees 5,000, 10 days time to the satisfaction of
SP border golf.
SP Border Corp.
Mas.
Item 32.
Here also, my lord, the opinion, my lord, is of 2019, my lord. And my lord, the husband of the petitioner, my lord, was picked up, my lord, on 25/5, the same day. My lord.
Okay. Opinion is at page
Page, my lord, 20, my lord, 16, my lord.
Page number
16, my lord, 116.
16. Okay. Okay, same order as earlier. Earlier matter was item number
31. 30.
Signed the and counsel for the petitioner. The response is there. Opinion is at page 16, dated 15/7/2019. Same arrested on 25/5/2025. Same order.
Public.
We are fixing it on same Monday.
Night.
Nine.
Public.
Upgraded item 33. .
Yes. Okay. Yes, I can just write the report bill or that. Yeah. Get it together. Yes, sir. Keep treating it faster.
You're seeking extension of order of 22.
Lost it. Otherwise, my lord, the issue involved, my lord, in this case, my lord, the digitally signed certified copy was not accepted. This is the only issue, my lord. And this case is covered, otherwise covered, my lord, by Mamta Hunik case, my lord. If you lost it, my lord, the opinion, my lord, page 60. And findings, my lord, page 63, my lord. This is the only ground. All the voter list, my lord, digitally signed, certified copy.
Which, please show us the documents?
Page 63, my lord.
Page?
Page 63, my lord, the opinion, my lord, in the writ petition. Document, my lord, 66 voter list, then 70, 77, and 97, along with the other. And findings, my lord, page 63, bottom, my lord, the submitted voter list are verified. Lordship got it.
Arrest question. Arrest question. Bail assist. My lord. My lord. No, my lord, in fact, that has not been considered, my lord. Your lordship will find that page 64 last page, my lord, last paragraph.
You,
Last paragraph,
just a moment.
page 64 last paragraph. Page 64, last paragraph. Even though we accept these documents, my lord, the link document, she has failed to prove the link. That must be. Page 64, my lord. Last paragraph. OPS submitted huge number of documents to prove his citizenship, her citizen. It is settled proportion
No,
of.
first of all, you see, you consider a evidence
Yes, madam.
and then say there is no link.
No,
There's
madam,
another way to say that your documents are not admissible because it is a electronic certified copy, and then say that you don't have the link.
my lord, the observation here, my lord, your lordship will find. Even though we accept, my lord, I accept that there probably that appreciation.
No,
may be
your
less.
acceptance would mean that this
No,
court in exercise
my
of
lord, for the time
certiorari.
being, if we accept this for the time being, my lord, even though we do not accept, but for the time being, even though we accept, my lord, these documents are genuine documents. The my lord voter list. Only my contention is that what is the link between the petitioner and the parents? That must only, my lord.
No,
My lord,
there's something more.
on due appreciation of the evidence, reduce the tribunal convinced that OP had miserably failed to establish link with Surat Ali and Manjula Bibi, whom he
Surat Ali
claimed
was
to be
DW2.
Yes, admissible, trustworthy.
Surat Ali was DW2.
Yes,
Father,
that's oral evidence, my lord. If they have a link between among them, my lord, then I have no objection, my lord. If they have a link, the petitioner and the father, my lord,
case 25, my lord.
if that document is there, then your lordship definitely can send back.
Case 25, 27. Electronic certified copy, man.
Page 25.
25.
They're in the same voter list, page
Same
26.
voter list. Serial number 45, father, my lord. 48, petitioner.
Then if they are in both same voter list, my lord, I have no objection that it can be sent back, my lord, for representation.
Okay. Yes, Verma, please come forward. You, Mr. Pang and Mr. Sharma also, we are not asking you to go back. Be here. You see, we are now in a difficult situation so far as the bench is concerned. The FT matters hearing will have to be delayed because we are taking up day to day this APSC matters, and we are not finding time to deal with both the items.
Yes.
So therefore, few of these hearings will have to be adjourned. Every day we have been having the CAVs.
Lordship, admission matters, Lordship can fix up for hearing.
We'll have to delay it for
Lordship.
after 2 weeks because we are not being able to because
There's
CAVs
Lordship.
CAVs are creating now a very difficult situation for us. It's just piling up.
Lordship, LCRs have been received and it's in the admission column. Lordship may fix up for hearing. the hearing.
That's why you are telling you'll have to assist us more now.
Lordship. Our assistance is always there, Lordship.
No, it's there. I'm not saying that it's not there. I said more.
Yes.
That I remember that advertisement of Pepsi. Dil mange more. Okay. To the members of the bar also, this foreigners matters for 2 weeks will have to be delayed. Otherwise, this hearing of APSC matters, we are not being able to do justice with both the items together. Okay, we'll pass orders after some time.
Only one more point, my lord, in this case. The voter list of the tribunal has pointed out, my lord, it's a translated copy of the voter list. That is a big issue.
You see, nobody, unless you show that it was a request made, you see, why will somebody give a translated copy if you don't have a robust system? That means you are doing it
I have
yourself.
indicated on the, my lord.
This, you are doing it yourself. That's number one. Second is, I forgot the provision in the Representation of the People's Act. There what happens that you have a voters list, which is in English and which is in the local language. So local language in Guwahati would be Assamese, in Barak Valley it will be in Bengali. So it's and the name of I'm saying it with the aspect of a what do you call this election petitions, where there is a requirement that a name of a candidate must match with that in the voters list. It may be English, it may be a local language, but if it is matches, then let us say that there are two J Pang. In the nomination is by two persons whose name is J Pang. Then what happens is that there's a under the relevant law of the conduct of elections, they say that one would be now referred as J Pang, son of so and so, or J Pang, son of B, for example. And so therefore they will it is for the returning officer to find out a suitable description to show that these are two different persons. So it is in that context I am saying. And if the name matches, then the election the petition cannot be said to be have been what you call wrongly presented or accepted. It's not a case of incorrect acceptance of a nomination paper. So this is the law. So therefore, if the Election Commission of India does not have a translated copy, it will not translate and give it to you. Supposing today you ask a copy that please give me a voter list of so and so, voter number so and so in Gujarati. You ask Mr. Islam, it will be rejected. It will be given only in that language in which they have the voter list. So it's not a question of translation. It's a misconception that there's an issue of translation. You have given vote. You have given a vote.
Yes,
Your voter list was in which language?
Assamese.
Was in Assamese. But you ask Mr. Islam, he will tell you after some time that there's also a voter list in English. Correct? So what happens is that the voters list is more prevalent if it's sent to village or sent to some polling centers. It's sent in by SMS. It's easier for people to understand. In Kasar district, it will send in Bengali.
Probably, my lord. There may be English record, there may be in English.
It has to be
also.
there.
Yes.
Mr. Ali, please give it to her. Find out paragraph 17.
The clarification is on 21.7, Lordship. আমার বোরহানুল ইমান আছে ইয়াতে ওদের ভলিউম বানাতে ভিডিও মু ডাইরেক্ট করতে
You've seen that?
Yes, Lordship.
In this case, this exhibit C was a photostat of the certified copy.
Yes.
And 18, the exhibit D is so and so and E. So therefore, the court says all these documents are not proof, they were merely marked as exhibits.
21.7 in Borhan Ali clarifies it, Lordship.
If the protected relies on a voter list, only a certified copy of such. So this is this clarificatory. Huh?
Yes.
So this was wrongly applied by the tribunal. Yeah.
Hmm.
Well, the learned counsel for the petitioner has made his submissions in support of assailing the impugn opinion, comma, the learned standing counsel for the FT matters has made her submissions in support of the impugn opinion on the ground that the petitioner has not been able to prove his link with his projected father and the grandfather. Next para. In this case, comma, the petitioner, comma, upon receipt of notice, comma, entered appearance and filed his written statement
2018 4 GMT 392.
and in support of his defense, comma, the petitioner has also filed his evidence on affidavit. Oh, thank you. And exhibited the following documents. This will be at page 61. Blue pencil mark. 1 to page 62, 1 to 9. Exhibit A to exhibit I. Full stop. From the evidence of the DW1, the petitioner has DW1, comma, it appears that in his cross-examination, comma, the petitioner has asserted that in the electoral roll of 1966, the name of his grandfather '66 voter is, where is that? His grandfather, namely Asmat, ASMAT, Asmat Sheikh,
Page 19, my lord.
appeared. Page
19,
19.
page 20.
Asmat, ASMUT, Asmat Sheikh, SHEIKH, appeared. And that in the electoral roll of 1970, that first one is exhibit A, 70 is exhibit B, within bracket exhibit B, comma, the name of his grandfather, Asmat, ASMAT, Asmat Sheikh, SHEIKH, as well as his father, Surat Ali, SURAT, Surat Ali, ALI, Sheikh, SHEIKH, appeared. Full stop. Which page is DW2?
Page, my lord. 22, my lord.
22.
Yes.
No, no, it is evidence of
Oh,
DW2.
evidence, my lord. Page 51, my lord.
51. So the projected father of the petitioner, Surat Ali Sheikh,
Cross 55.
it is only Surat Ali. There's something wrong somewhere. Why this name is cut, page 51?
Page
Why it is cut? The name Sheikh is cut. Why?
in affidavit, my lord.
Yes, why?
Check was cut and signed by, there's a signature also.
Why? Why?
Mm.
Why this has happened? It leads to an anomalous situation. You understand why I'm asking that? You project that your father's name is Surat Ali Sheikh.
Lordship, and
Then
he-
Sheikh is cut. And again, the signature contains an
Signature is
Assami Sheikh. Why?
Sheikh.
Why you create an anomaly in your evidence? Have you said anything about this?
In written statement, has been said, my lord, that Surat Ali Sheikh, Surat Ali Sheikh and Surat Ali, my lord, in written statement, my lord.
No, but you see,
Regarding-
from the evidence you create an anomaly. That's
Hello.
why we wanted to look at it. Here the signature is Surat Ali Sheikh in Assamese. Is it Sheikh or Shak? I don't know.
Sheikh, my lord, as is.
No, Assamese,
In
Assamese.
Assamese, my lord.
Signature. Shak, I think. It's not Sheikh.
Look. Yes.
Because if you can't write Sheikh correctly, neither you are Assamese nor a Bengali.
এই কাজটা আছে পিস করলে দূরত আছে। একটু দূরতে
Then you don't, then the link is disconnected. Suraj Ali Shok. I don't know how it is pronounced. Yes, Mr. Sok. Oh, Hok. Hot.
Sok.
If it is Hot, then everything disconnected. Now your opinion becomes correct.
Page 26, my lord, is
26.
along with the father, my lord.
No, I understand, but you'll have to give some explanation. You better give an explanation, otherwise from positive order to you get a negative order. Even by affidavit, you can't change it now. But we give you an opportunity, Mr. Ali. You just adjourn it on your prayer.
Then, my lord, I may be considered, my lord, because police has given, my lord, time to produce the order, my lord.
Police is giving you time. You have a very long hand. You have a very long hand.
Because there is the interim order is there, my lord.
But there is an order of bail.
Lordship, but
Then-
he could not, my lord, communicate and, my lord, and he did not appear, my lord, along with the bail order.
22 extension order, we
Therefore, we clear for extension, my lord.
An extension
Right.
has been filed, Lordship, when in 25 after 3 years.
you use your connections.
Lordship.
He was out of station, out of Assam, my lord.
That means he has no regard for the court's order. He is on bail and he hasn't even appeared, Lordship. And after 2.5 years, he's asking for extension of time. Very
You-
bad conduct
can-
of the petitioner,
You
Lordship.
can fix it on Friday or Monday if you want, but we will not grant bail in on the extension of bail in on such conditions.
Lordship,
22 to
even we have
25.
Objections.
3 years.
In spite of knowing he has a reference against him, he has got a declared for an order. He's got relief and again he's not appeared, Lordship. Very bad conduct.
If you say we can fix it on Friday or Monday, whenever you want, but we are not extending the bail. When do you want?
On Monday, my lord.
Monday, okay. In, all sides are represented in course of examination of documents. Which are available in the records of the tribunal, comma, note the discrepancy of the name of DW2 in print and signature. Stop. Accordingly, on the prayer made by the counsel for the petitioner, the matter sends John to do to enable him to obtain instructions. With liberty to file affidavit, if any, list on
11.
9, 11, okay,
11.
11, 6, 2025.
What petition copy for the book? About the client. No, no.
Item 10 for admission.
Lordship, LC has not been received.
2019,
Lordship, on the last occasion, Lordship wanted to know the mode in which the registry has sent a reminder before the tribunal.
oh yes.
Call to
It
it,
is been sent to email also. It is sent by post and email both.
Which district is it now?
No, no,
No, no.
no, no, I know.
Also as a represented pursuant to order dated 30/5/2025, the registry has put up a note to the effect that the records of the learned tribunal records, the relevant records from the member, foreigners tribunal number 2nd, Nagaon, was called White memo number 292/WP/FT dated 6/5/2025 by speed post as well as email. So however, the records are not received. So the registries shall send a fresh reminder for the records to the
52, no?
52.
same email address to which the notice was earlier sent. Full stop. The said the learned member, foreigners tribunal 2nd, Nagaon, shall take notice that in the event the records are not produced before the registry of the are not sent to the registry of this court, orders would be passed on the next date for personal appearance of the superintendent of the said learned tribunal. Next para. List on 13/6/2025. Okay. We've said for which orders would be passed on the next date. You strike out that and you say, as the notices were already sent by so and so earlier stated. The court is inclined to call for the personal appearance of the superintendent, Ordinance Tribunal Second Nagaon. Appear before this court on 13/6/2025, along with the records of FT case number 26 of 2014. In the case of State of Assam versus Ajufa, AJUFA, Ajufa Khatun, KHATWN, which was disposed of by opinion dated
Lot of the include orders at page 67. 14/12/2018.
14/12/2018. You said page
67, Lordship.
67. Full stop. The registry will send a copy of this order to the
Lordship,
down.
can we get the records, Lordship? We can always call them up and get the records, Lordship.
Okay.
Then SP shouldn't not be bothered, Lordship, we'll get it.
No, we are calling for the superintendent, not the FT.
Yes, Lordship. Superintendent of the
No,
court.
it's okay. You can get it. We won't enforce that order. Let's strike it out. See.
Record.
You stop it where we say that the requisition was issued by the registry, but so and so dated 6/5/2025. Next para, at this juncture, the learned standing counsel for the FT matter is submitted. That no, don't make it her submission. You say accordingly, we request the learned standing counsel for the FT matters to
Obtain the
to obtain the records of FT case number 26 of 2014 in the matter of State of Assam versus Ajufa Khatun, which were disposed of by the learned member, Foreigners Tribunal Second Nagaon, by opinion dated 14/12/2018, to the concerned officials of the Home and Political within the B department. Next para, to facilitate.
Lordship, the petition, she was earlier declared as Indian Lordship. That record was also called for. Page 37, Lordship.
37 also, okay.
Lordship.
As well as records of
FT case number 3237.
page 37, FT case number 3231 of 2011 in the matter of state versus Musamat MUSSTT, full stop, Ajufa, AJUFA, which were decided by the learned member, Foreigners Tribunal Second, Nagaon, wide opinion dated 16/3/2015. Next paragraph, the learned standing counsel for the FT matters is at liberty to send the downloaded copy of this order to the concerned authorities, to facilitate requisition of the records, requisition and production of records. Next paragraph, based on when 13th or 13th or 16th. Okay, 16. Okay.
Lordship.
Item 11.
Right, please, your lordship.
Yes.
My lord, the matter pertains to custodial death of the petitioner's son, my lord, who was an accused in the Hajo PS case, and he was apprehended from North Lakhimpur.
On last occasion, Lordship has directed the registry to get the records of the case diaries. The office note says that those have come.
Okay. But Mr. Nath will need your assistance. It's too voluminous. Please also allow Mr. Patwai to go through it.
Go through it.
Please go through it and then tell us, because we really don't have time to produce the same.
Lordship may keep the matters after on a different day. In the meantime, we'll go through.
Please,
Relevant thing is like. Yes,
please
ma'am.
coordinate
Please
with
go
him and then
yes,
go through it. It will be easier for us to.
yes. Assist him.
We take it up on next Monday. In the meanwhile, you have 1 week's time to go through it.
Yes.
It will be
That
sufficient.
will suffice.
Mr. Nath,
Lordship.
you have to facilitate him to come to your office and then
Yes,
go
absolutely.
through it.
Lordship, can this be taken little later? On 13th, Lordship has fixed one case. That is also custodial death. The encounter. If it goes to 16, it will be better.
16th.
16.
Okay.
Yes.
Mr. J. Patwari, learned counsel for the petitioner, as well as Mr. D. Nath, learned senior government advocate. Along with Ms. M. Das is present. Are present. Next, pursuant to the order dated 11/3/2025, comma, the case diary pertaining to, you will copy from the note sheet. Huh? This, I'm putting a pink flag. Records of number 1, Hajo PS case number 1993 of 2021. Second, North Guwahati PS UD case number 10 of 2021. Then comma, and number 3, North Guwahati PS case number 194 of 2021 is received. Stop, as this case diary is voluminous, the court is inclined to hand over the scanned copy of the case diaries to the learned senior government advocate for perusal. And to address the court, full stop. The learned counsel for the petitioner is also granted liberty to peruse the case diary in the office of the senior government advocate, so as to enable him to make notes and address the court. Next para. List on 16/6/2025.
Deeply read.
Because since we are hearing those matters, we'll not be
Yes.
able to devote time to read this.
Malo.
There is also a miss case. Please check this. What is this miss case?
Not wise.
Let's check it out. I have not checked it. Mr. Patwari, just see this also.
But, these are records relating to the ministerial inquiry. The judicial magistrate has conducted an inquiry under 176 CRPC.
Okay.
That record is there.
Okay.
Note sheet and all.
Just also say along with along with 1, 2, and 3, along with the records of magisterial inquiry.
Lodge.
Please have this also, because
Yes.
it will be relevant for Mr. Patwari.
Lot. We'll see.
Yes, next. Yes, next. Yes, item 12. Yes.
May it please your lordships.
Yes.
My lord, this the petitioner as appellant's lordships approached before this honorable court against the order of learned single judge lordships. Lordship, this record of Assam Board of Revenue as well as records of additional Deputy Commissioner Kamrup Metro have received lordships. These records of ADC, it is with the learned government advocate lordships. And also this record of Assam Board of Revenue, it is with the records lordships. Now as records have come lordships, and also the lordships, I have gone through the records also. And lordships, I have prepared a short note lordships. Short note lordships. Yes, reports.
Which page is the judgment of the learned single judge?
Lordships. Pays 180 lordships. 180 lordships.
Which is the contradictory judgment to the Board of Revenue's order? Which is the contradictory order? It is projected here that there is a contradictory order by the Board of Revenue. Which is that order?
Well, actually they filed an appeal petition for ownership right over the land. That ownership right was granted earlier by the Deputy Commissioner.
Yes.
On appeal, that was set aside. And they preferred a review application that also rejected. Against that rejection, they
No, because we find that there is something, some observation here in regard to existence of a contradictory order. What we gather is that there was first claim for ownership rights, and it was by virtue of the Non-Agricultural Area Tenancy Act. So it was a Rayati case. On that, the ownership right was declared. After that, the ownership right on declaration was also published in the Gazette.
yes.
And after that, there is a series of litigation. But in support of one of the statements made in the writ appeal, that there are contradictory judgments of the Assam Board of Revenue. We have not been able to track that. Which is the contradictory judgment by the Board of Revenue? Which is that contradictory order?
That will submit by my learned friend.
No, but is it a fact or is not a fact that there are contradictory judgment by? No contradiction by the Assam Board of Revenue. Because initially there was a remand by the Board of Revenue to the Deputy Commissioner. So it is at that place and the contradictory statement where I lost track.
So far, I have gone through the record there. I found no contradictory.
Okay. But although you are stating that, but here it appears that there are various appeals and reviews filed. And therefore, there are multiple judgments and orders to be considered. Can both of you make a separate list of those multiple orders passed so that we can identify which is the what part is the contradictory judgment? Because there's some overlapping, some here and there. But since there are several orders, it is at this stage I lost track.
In single judges, single judge judgment, all has been discussed already.
Can you identify which is the contradictory order according to you?
Lordships, I have prepared a note accordingly.
Please pass it on.
Make extra copy.
Extra copies.
This occupation rights was declared in your favor, Mr. Sharma,
Lordships.
in your favor.
Yes.
But if there's no contradiction, then we don't find any infirmity in the order of the single judge. If we don't have time, we'll take up some other day. Due to both sides, including Mr. A. Sharma and senior counsel for the respondents, present. So due to positive time, the matter cannot be taken up today. Next, this is the matter for. This is already admitted.
Yes, admitted.
Appeal is admitted, I think.
Lordship, yet to be admitted, Lordship.
Huh?
Yet to be admitted, Lordship. Lordship, my humble prayer, at this stage the appeal may be admitted and may please be posted for hearing after vacation, Lordships.
Record I said, no? Yes. Record I said. It's a separate file. Me too. Very basic. Nice, it's all good. And very good fun. Okay. So, you see that in view of the nature of issue raised in this intra-court appeal, the appeal stands admitted for hearing by issuing rule returnable forthwith without requiring any fresh steps to be taken. As you are appealing for all the respondents?
Yes.
As all the
And record has already come.
all the parties are represented. Next para. As per the office note, the records of the courts below, the trial records have been received. So accordingly, this is the matter for hearing. On 28/7/2025. List accordingly.
Interim order passed along with.
Interim order passed earlier stands extended till the next date of listing.
May I plead the Lordship? Lordship, in item number 23, we have a urgency in this matter, Lordship.
Pardon me?
Item number 23, I have a urgency, Lordship. As today from 2 p.m. APSC matter will go on.
Item number
23.
23.
Lordship, may I pray to take up this matter tomorrow, Lordship?
What is the issue regarding?
Lordship, the matter actually related to the catering NIT issued in respect of catering services of VGR. But Lordship, the private respondent without participate challenge the NIT and learn single just stay the learn single just stay the NIT to finalize Lordship. Or Lordship may, if Lordship can take today also the tomorrow.
This week will not be able to take up. We'll take it up next Monday.
Next Monday, Lordship.
Uh, the positive time the matter cannot be taken up today. So we don't counsel for the appellant. Submits that there's some urgency in the matter. So accordingly list on 9/6/2025.
Well, if your lordship.
Most of like-
My lord, may I pray, my lord, item 13, 15 and 17, earlier also, my lord, left over. So my lord, may I pray for.
For 2 weeks, it's not coming up. Unless we finish the PSC matters, we are not taking up any other hearing. We will not be able to.
Day after. So,
We will not be able to take up for 2 weeks, not day after tomorrow.
my lord,
Next 2 weeks, we will not be able to take up those hearings.
my lord. All right, sir.
It is not just, it's physically not possible for us to
Yes, sir.
take up any further hearing. Yes, item 26.
26, my lord, can it be taken tomorrow, my lord, morning? I have sent my, they will give me the instruction, but details.
Okay. All sides are represented. On the prayer made by Mr. J. Pank and his standing counsel for the FT matters. Come on, list this matter. Tomorrow is like 5, 6. We just need a solution.
Yes, yes,
we-
yes.
we have expressed
I'll get
concern.
it. How can it be solved, my lord?
Mhm.
I'll get details.
May I, Lordship? Yes. In fact, Lordship, I know Lordship and has been very, very patient in hearing this matter non-stop for so many days. And I know Lordship and Ladyship have several responsibilities that keep this bench occupied with many things. But I was going to make a request at the cost of burdening Lordship's load by saying if I can over the next 1 or 2 days get a little more time, I can finish the propositions in a flow. Subject to Lordship's, of course, convenience and Ladyship's special bench. So even if we start at 12, for example, or if we post lunch can go for an additional hour, I'll be so obliged.
We are expecting more cases in foreigners tribunals to come back. There's a recent development. And
yes, Lordship, I'm aware
Yeah.
of it. Which is why I'm also curtailing. In fairness, I must tell Lordship that I was sitting with my colleagues and I was saying, can we cut a few paragraphs? Can we make it more focused without losing, of course, the opportunity of giving the complete picture and the point? But I was, Lordship, that's why saying if before that deluge comes, I was just hoping that over
let
the
us
next
see,
2 days.
once we start, then we think.
Well, Lordship, I will certainly say that I'll start and I hope it'll lead to some thinking. The Lordship, I'll quickly take off from where I left it yesterday, Lordship, Ladyship. So basically, as Lordship would have noted, I had given the set of propositions broadly. They are intertwined, the submissions by the appellants. And each one I have to finally show how, despite being intertwined, each principle is settled by the Supreme Court. So yesterday I have labored and placed before Lordship everything related to probation to drive home the point that all of them, and I will come to that, today I will close with that notification that Lordship was referring to, is that all of them are only probationers or temporary employees. Second, there is no concept of implied vested confirmation or deemed confirmation. There is a specific act under the rules. That has not been performed. So that argument cannot come. This will Lordship then go down, just to give Lordship a flavor of where I'm taking the arguments between today and tomorrow, is I will then show the argument of an inquiry of some sort should be there. I will start dealing with that, Lordship. That will then go to Lordship the question of principles of natural justice and the allegation whether it is not being complied, should it be complied. So I'll be, Lordship, taking them, and finally I will touch upon 311 also in that thing. So Lordship, if we may come back.
One of the forceful submissions was, if we were permitted to allow to participate in that inquiry, we would have exposed that what is right, what is wrong. So that opportunity was also lost, not only in the departmental proceedings, but preliminary inquiry, if any, in whatsoever way it was made.
So Lordship, the investigation was there, they were arrested. 3 people decided to be approvers to assist that investigation, to assist, more importantly, the process of the court. Because in an approver's case, Lordship, it is the court which takes that call, not the investigative agency. Additionally, Lordship, I will weigh that argument against the counter argument, which is the doctrine of empty formality. And that will start getting culled out in the judgments over today and tomorrow. That an outcome which is expected to be the same, courts will not indulge it. I will additionally, Lordship, also be touching upon the writ jurisdiction and the arguments they are making within it. So all of it will get answered, Lordship. And at the end, I will answer anything that specifically Lordship feels that I may not have touched or I may not have clarified to the extent that Lordship wished I should have taken the argument to. So Lordship, I'm on my judgment in the compilation, the last 2 on this set of propositions, that if the applicable rules provide for extension of probation, no person can claim deemed confirmation in service unless a specific order of confirmation is passed. I took Lordship and Ladyship yesterday through G. Ramaswamy versus Inspector General of Police, Constitution Bench, Lordship, 1964.
You want us to take the same file that?
Yes, Lordship. And today I will at the end come down to Kavita Das's file at the end, which has been informed to. 2 judgments are left in yesterday's compilation. So I'm not going to the fresh one. If time permits, I'll start the next one, Lordship. Then, Lordship, I had shown Pratap versus Union of Territory of Chandigarh, 1979, which is 3-judge, which also relies on Dharam Singh, which is another constitution bench. Then, Lordship, Satyanarayan Athya versus the High Court of Madhya Pradesh, which is the case of a civil judge, Lordship. Wasim Beg, which again relies on these principles, though in facts it was different to us, the end he got it, but the principles were reiterated. And Lordship, I am today going to come to Justice Chandrachud's judgment of 2019. So I'm bringing it from 1964, broadly picking up judgments every decade, if I can say, or every few years, to show how the law has consistently been upheld. So today I'll be showing, Lordship, Durgabai Deshmukh Memorial Senior Secondary School versus J.J. Vasu Sena. This is a 2019 judgment, Lordship. That's the last one, second last one in my compilation, Lordship. And this is Justice Chandrachud and Justice Anirudh Bose. So once Lordship has the judgment, I'll read para 1 and 2. This judgment, Lordship, will be very interesting because it directly deals with the argument of a probation period, extended period of probation, and the requirement of a confirmation. So this is specific. And in this judgment, the law has been sort of, dealt with completely. We had shared
Before you begin this,
Lordship.
there's one more query.
Lordship.
You can respond whenever you want. A forceful argument was made because once you treat some people as approver, then for them there's a departmental proceedings. The argument was that so far as the issue of approval is concerned, is within the domain of the criminal court. And how a department can take a different view. That's one of the
negative equality. So that we'll also cover. I'll come to that.
They say it's not negative equality.
That's what they are professing, Lordship. Our counter is, and Lordship, you can't use Article 14 in such a situation. Second, Lordship, in an approver's case,
They are
Lordship,
not projecting our Article 14. They are saying that once you have bifurcated two sets, then why there are two criteria for the same set of persons?
yes, Lordship. I will place a judgment, Lordship, which has dealt specifically with approvers and how their status changes.
Okay.
So I'll come to that, Lordship. At the end, I'll use it as one of my, there are multiple single judgment points that I will raise instead of going into 7 judgments on it, just to drive home at the end. What are those different arguments? So approver ka wahan dal dena end mein. And also what Lordship said in terms of the earlier one. So Lordship, if I may, if you have the page, Lordship.
Yes.
Durgabai Deshmukh.
Yes.
Lordship, para 1. The present appeal arises from a judgment of a division bench of the Delhi High Court dated so-and-so, setting aside the judgment of the learned single judge in a letters patent appeal. The division bench accepted the deemed confirmation of the services of the first respondent, who was a probationer in the school of the appellants. So now, Lordship, it will deal with 3 things: probation, extended period of probation, confirmation requirement, and the division bench accepted the argument of the deemed confirmation, which the Honorable Supreme Court has eventually reversed. Para 2 for facts, Lordship. Allowing the appeal filed by the first respondent, the division bench held that under Rule 1051, that was the rule in the case, Lordship, it's quoted also, read with the first proviso of the Delhi School Education Rules 1973, the maximum period of probation permissible is 2 years. The High Court held there is a deemed confirmation of the services of a probationer who is continued in service beyond the maximum period of probation, even without the issuance of an order of confirmation by the appointing authority. Agreed, the appellant school is now before the Honorable Supreme Court. That's the argument. Now, Lordship may come to para 19. That will be para 18 of your compilation. I am, of course, Lordship, Ladyship, carrying the SCC copy, which I had marked. Online. But Lordship may come to para 18, where Rule 105 of the 1973 rules are quoted. May I read, Lordship? Probation 105. Probation 1. Every employee shall, on initial appointment, be on probation for a period of 1 year, which may be extended by the appointing authority by another year, with the prior approval of the director, and the services of an employee may be terminated without notice during the period of probation if the work and conduct of the employee during the said period is not, in the opinion of the appointing authority, satisfactory. So there is a 1 plus 1. Like in our case, we have a 2 plus 2 except APS. Next page, Lordship. We'll come to 1052. If the work and conduct of an employee during the period of probation is found to be satisfactory, he shall be on the expiry of the period of probation or the extended period of probation, as the case may be, confirmed with effect from the date of expiry of the said period. Now, Lordship, this is very interesting because the rule itself speaks at the expiry of the probation period. But now let us see how their lordships have dealt with this. Para Lordship 23. The points of law that arise for determination in the present appeal are: 1. Whether the words "by another year" appearing in the principal part of Rule 1051 and in the first proviso to Rule 1051 limit the total duration of permissible probation to 2 years, and second point, whether the 1973 rules require the issuance of an order of confirmation for a probationer to be confirmed in service. Lordship may come to para 26.
Spending para.
Yes, 26. Yes. Lordship, what I just read was para 21 in Lordship's. Now Lordship may come to para 26 of Lordship's compilation. This deals with the purpose of probation. So two judgments, Lordship, this one and another one specifically touch on the purpose of probation. The words of a statute should be understood in the sense in which they best harmonize with the subject of the enactment and the object which the legislature has in view. This principle should be a useful guide in interpreting the provisions of the delegated legislation in this case, namely Rule 105. The purpose of probation is to enable an assessment to be made of the performance of an employee. It serves as an opportunity for probationers to establish, by the dint of their work, which is rendered during the period of probation, that they are suitable for being retained in service. On the part of the employer, probation enables the appointing authority to determine the suitability of the probationer for retention in service. Now, Lordship may come to para 40, Lordship, of your compilation. Right. Which starts with the words, "The High Court concluded." Para 40. The High Court concluded that Rule 105 fixes a maximum probationary period of 2 years, and consequently the continuation of the services of the probationer beyond the period of probation would amount to a deemed confirmation of service even without an order of confirmation. This is what the learned division bench holds. Consequently, the case of the first respondent was, according to the High Court, within the second category of cases enumerated in Satya Narayan Jhavar. I have, Lordship, yesterday shown the three separate situations with regard to probation and deemed confirmation, but it is going to get covered here too. This court in Satya Narayan Jhavar enumerated 3 lines of cases. The third stipulates those cases where the rules prescribe a maximum period of probation, but also require a specific act on the part of the employer of issuing an order of confirmation for the purposes of confirmation. In such cases, there is no deemed confirmation of the services of a probationer on their continuation in service beyond the maximum period of probation, which is the argument we are also putting forth. Next para, Lordship. Admittedly, the appointment letter does not stipulate that the first respondent shall be confirmed upon the expiry of the probationary period. Rule 105(2) stipulates that an order of confirmation may be issued if the work and conduct of an employee during the period of probation is found to be satisfactory. Rule 105(2) lays down a condition precedent. Lordship may mark that. And this is an argument that we are taking, that in every one of the services, there exists the condition precedent which has to be complied with before confirmation can be claimed. Lays down a condition precedent to the issuance of an order of confirmation. It is only if the appointing authority is satisfied with the performance of the probationer that an order of confirmation may be issued. Rule 105.2 contains an explicit stipulation requiring the issuance of an order of confirmation by the appointing authority upon its assessment that the performance of the probationer has been satisfactory. Again, this is the identical argument we are pushing, Lordship. The mere continuation of the services of a probationer beyond the period of probation does not lead to a deemed confirmation in service. It is only upon the issuance of an order of confirmation by the appointing authority that the probationer is granted substantive appointment in the post. So therefore, Lordship, this requirement of satisfaction under the rules in every one of the cases of the appellants by the appointing authority, who is the governor in our case, Lordship, is applicable to all of them. This is the condition precedent to confirmation. And this has not been done in a single case of the appellants, not one case. There is a letter of confirmation. There is a satisfaction with regard to confirmation. Not in any case this has been done. It does not exist in the case of any of the appellants. And therefore, Lordship, everyone's discharge of each one of them is during the period of probation when they were only probationers or temporary employees. I'm not reading. I'm going to show it. Lordship may come to the next para. Was Lordship going to ask me something? Lordship, the next paragraph is quoting G. Ramaswamy. I have already dealt with it, Lordship. And this was the first judgment I read, Lordship, the Constitution bench. It is repeating what I read yesterday, Lordship. So I'm not repeating it, Lordship. Next paragraph, Lordship, is with Kedarnath Behel versus State of Punjab. Now, Lordship may come to the last line of that, where the last line is rejecting this contention. A 3-judge bench of this court held. So within Kedarnath Behel, a judgment is quoted, which I'm reading, which is the sub point 9. The law on the point is now well settled. Where a person is appointed as a probationer in any post and a period of probation is specified, in our case 2+2, it does not follow that at the end of the said specified period of probation, he obtains confirmation automatically, even if no order is passed in that regard, unless the terms of the appointment clearly indicate that confirmation would be automatically follow at the end of the specified period, or there is a specific service rule to the effect. The expiration of the probationary period does not necessarily lead to confirmation. At the end of the period of probation, an order confirming the officer is required to be passed, and if no such order is passed and he is not reverted to his substantive post, the result merely is he continues in his post as a probationer. So therefore, Lordship, this is consistent in all the cases. This is our argument too. Next, Lordship, we note in the next paragraph, their Lordships have referred to several judgments, Lordship. And if Lordship can come to the next paragraph where it relies on the Headmaster versus Lawrence School. Recently in Headmaster versus Lawrence School.
44.
Para 44, Lordship.
Yes.
Again, Lordship, it is reaffirming, I'm not reading it, Lordship, just pointing out, reaffirming that the concept of deemed confirmation will not exist if there is a specific requirement under the statutes for the satisfaction to be given by the governor. And that's the identical settled law, consistently, Lordship. Then, Lordship, we come to para 45, Lordship. It emerges from a consistent line of precedent of this court. And Lordship, we are talking Constitution bench downwards. Constitution bench 3-judge and 2-bench consistently. From 1964, now we are in 2019, Lordship. It emerges from the consistent line of precedent of this court that where the relevant rule or the appointment letter stipulates a condition precedent to the confirmation of service, there is no deemed confirmation of service merely because the services of a probationer are continued beyond the period of probation. It is only upon the issuance of an order of confirmation that the probationer is granted substantive appointment in the post. And then, Lordship, it deals with Rule 105.2, which is to the facts. And that is basically saying that there was no satisfaction, Lordship. Lordship may then come to, just Lordship may note, para 49, Lordship. It's Lordship, para 48 onwards, they are dealing with Dharam Singh.
49
So Lordship, para 49, after quoting Dharam Singh, the Constitution bench, it is reaffirmed here or relied upon here, Lordship, in para 49. In Dharam Singh, the Constitution bench held that the continuation of services of a probationer beyond the maximum period of probation would amount to a deemed confirmation of service only in, specific only in, the absence of a stipulation in the relevant rule requiring the probationer to pass a test or fulfill any other condition. So, Lordship, there is only the exception does not apply to any of the cases of the appellants because the rules require or have the condition precedent of a satisfaction to be expressed. In the present case, Rule 105(2) stipulates the satisfaction of the appointing authority as a condition precedent to the issuance of an order of confirmation. The High Court has thus failed to notice the distinguishing features which emerge from this court's judgment in Dharam Singh. Lordship may just come then, Lordship, to the para number 57 towards the end of the judgment, where the final judgment is passed by Lordships. Para 57, Lordship.
We hold and declare.
We hold and declare that the words by another here in Rule 105(1) of the 1973 rule stipulates that the maximum period of probation permissible is 2 years. And 2, Rule 105(2) stipulates a condition precedent to the issuance of an order of confirmation. The continuation of the services of a probationer beyond the period of probation does not amount to a deemed confirmation of service. It is only upon the issuance of an order of confirmation by the appointing authority that a probationer is confirmed in service. Lordship, I will come to my last judgment on this point, which, Lordship, is a 3-judge bench and a recent judgment. Well, relatively recent, Lordship, it's only a few years ago. Rajasthan versus Priya. Lordship, this is the second judgment which will also touch upon the requirement or what is the concept behind probation. It's a short judgment, Lordship, by just 2021, 13 SCC 151. Rajasthan High Court versus Priya. And Lordship, this is by then Chief Justice Bobde, Justice Gawai and Justice Suryakant. I will deal with the facts, Lordship, briefly. Para 1. 1 to 4 are the facts. But Lordship, the facts also make interesting reading, so I shall labor on it slightly.
This is at what point?
Same continuation. We are on the same principle, Lordship. It's my last judgment. Because, Lordship, I have already shown the rules. I have dealt with the judgments. I have brought, Lordship, now to 2021 3-judge. So each one of them, Lordship, is establishing the same principle, which is the consistent settled law. And this is to which also in the case of the police, and which I'll come to my final argument on that OM, Lordship, after this, to say that there is no concept of deemed certification, confirmation. The condition precedent is the satisfaction, which has not been issued. The Lordship may come to para 1. These civil appeals have been preferred by the Rajasthan High Court. Now, Lordship, this is very interesting. In this case, this single judge, the DB, actually holds on the arguments of principles of natural justice, everything in favor of this judge who was not confirmed. And then the matter comes from the High Court in appeal to the Honorable Supreme Court. So this is what the point I'm making, whether it is this or Satyanarayan Athya or the others that I've shown. Lordship, in each one of the cases, it doesn't matter what the service is. The principle of law is identical and it has been used across. And the principle of law is if there is an unsuitability attached to the probationer who is to occupy a public office, then it is incumbent upon the authority, or the authority has every right under the rules to discharge that officer. It doesn't matter whether it is judicial, executive. As long as it is in public office, this can be done, and there cannot be a plea of a deemed probation and the argument of inquiry, which will get also covered as we are doing these judgments, Lordship. The argument of principles of natural justice and its violation. All of these also, while professed, the court has held in terms of the statute or which govern the employment, that has to be followed. These civil appeals have been preferred by the Rajasthan High Court against the order dated 16th of December 2014 by a division bench of the said High Court, when the said High Court dismissed a petition of review of its earlier order dated 19th of November 2014, wherein the High Court had allowed the writ petition filed by Ved Priya, respondent 1, a former judicial officer, and directed his reinstatement with consequential benefits and seniority. Respondent 1 was recruited into the Rajasthan Judicial Services in 2002, appointed a civil judge, junior division, cum judicial magistrate. Please mark, Lordship, he was placed on probation for a period of 2 years with effect from August 2002, which was later extended by a further period of 2 months in July 2004. Certain allegations of misdemeanor and corruption in discharge of judicial functions were received. Now, this Lordship is at a much higher footing than my case or our case. In this case, all of it is at the entry point. This is a case which is involving allegations of misdemeanor against someone who is doing it while in office. So let's see what Lordships hold. Certain allegations of misdemeanor and corruption in discharge of judicial functions were received during the probation period against a few judicial officers, including Respondent 1, on the basis of which the Registrar Vigilance, so the equivalence would be the police here, the Registrar Vigilance of the Rajasthan High Court called for the records and submitted a report in August 2004. So I'm drawing the equivalence. Registrar Vigilance, their authority, here the police, report is the investigation. This report was put forth before the Administrative Committee of the High Court, along with a wealth of other material, while it was undertaking the confirmation process of over 93 probationary judges. Pause, Lordship. This is on the administrative side. In our case, it would be the government and the administrative machinery. This 5-judge committee on the administrative side, Lordship, sought to determine the suitability of the probationers as per the terms and conditions of the appointment by evaluating their integrity, knowledge, conduct, and behavior. In this process, the committee relied upon numerous material, including reports. So there is a reliance on a report, in our case, the police report, submitted by their district judges, inspecting judges, ACRs, as well as aforementioned reports submitted by the Registrar Vigilance. After due consideration, it was recommended that the services of 90 officers be confirmed, the probationary period of 1 officer be extended, and the services of 2 judicial officers, including Respondent 1, not be confirmed. The report was placed before the full court of the High Court, and in September 2004, it confirmed the recommendations. Consequently, and on the recommendation of the High Court, the state government, by the order dated September 2004, dispensed with the services of R1. No notice, Lordship, no involvement in the process. No hearing, none of it, Lordship. Respondent 1, being aggrieved, approached the Rajasthan High Court on its judicial side and filed a writ petition seeking quashing of the termination order as well as reinstatement of his services. It was vehemently contended that the termination order was punitive and as a result of subjective notions and was delivered without due inquiry or hearing. So, Lordship, it's an identical argument. In this case also, no hearing, no notice, nothing. Identical argument before Lordships. Then, Lordship, para 5 is dealing with what the division bench relied upon. We can come to the last sentence of para 5, Lordship, before para 6. The court accordingly quashed the termination order and directed reinstatement. Para 6, Lordship, deals with the review. And the review is dismissed, Lordship. Now the contentions of the party becomes relevant, Lordship, and we can come to para 9. Para 9, Lordship. Yeah. Placing reliance on past precedents and the provisions of the Rajasthan Judicial Service Rules 55, it was urged that the services of temporary employees and probationers could be terminated without attracting the operation of Article 311 of the Constitution. It was highlighted how no mala fides had been alleged or proved, and in such a scenario, the only limited issue, Lordship, which could have been gone into was as to whether or not there was due application of mind before taking the innocuous administrative decision. 10. On the other hand, so this is the state's arguments. The respondent once submitted that an opportunity of hearing was one of the most fundamental protections known to law, and no one could be condemned unheard, irrespective of his status as a temporary or probationer employee. Now, Lordship, here also he relies upon Shamsher as the learned counsels for the appellants have. Let's see, Lordship, what is the argument from Shamsher Singh that is used here?
Except one. Shamsher Singh was not, was distinguished by one.
Except one. Lordship, so actually, Lordship, there are some judgments. Lordship, there are some judgments that are relied by everyone. And Lordship, I mean, in fairness, if I may say, some of them are books by themselves, very detailed judgments, that on reading it from the beginning to the end, you can take arguments in the entire universe around it. So it doesn't matter which side you are standing in, there is an argument that fits for you. So these are master judgments, Lordship, that can be used by anyone. So Shamsher Singh, Tulsiram Patel, they are very important judgments, Lordship. However, within them, they have crafted within them also what can be the exceptions. So there's no hard and fast rule, which is why, Lordship, our endeavor is to place before Lordship what is the consistent line beyond that period up to the latest. Relying upon Shamsher Singh versus State of Punjab, it was buttressed that notwithstanding the provisions contained in the statutory rules or employment conditions permitting termination of services of probationers without reason, if one was discharged on the ground of specific allegations or inefficiency without proper inquiry and reasonable opportunity of hearing, such an action would amount to removal from service within the meaning of Article 3112 of the Constitution. So this contention is of the respondent. Analysis, Lordship, starts at para 30. One thing, Lordship, we couldn't realize in this judgment is who authored it finally. Normally, we get the privilege of knowing who has authored it. And it is possible, Lordship, which is what we debated, that it was dictated in open court, which can happen, but it's a detailed judgment if it is dictated in open court. Analysis, para 13. At the outset, we may observe that both the appellant as well as the impugned judgment have elucidated the correct statement of law regarding the width and sweep of judicial review by a high court over the decisions taken by its full court on the administrative side. Although it would be futile task to exhaustively delineate the scope of writ jurisdiction. Now, Lordship, this becomes important because now we will also rely on other judgments dealing with the scope of the writ proceeding. The scope of the writ jurisdiction in such matters, but a high court under Article 226, and Lordship may please mark this, I am emphasizing it. But a high court under Article 226 has limited scope and it ought to interfere cautiously. The amplitude of such jurisdiction cannot be enlarged to sit as an appellate authority, and hence care must be taken to not hold another possible interpretation on the same set of material or substitute the court's opinion for that of the disciplinary authority. So this, Lordship, is something that I will also build in another judgment, but this is not an appellate proceeding, which is what they say. In the writ jurisdiction, the limits are being are settled here by Lordships in this judgment. This is especially true given the responsibility, Lordship, Article 235 doesn't apply to us, para 14. The present case is one where the first respondent was a probationer and not a substantive appointee, hence not strictly covered within the umbrella of Article 311. The purpose of such probation has been noted in Qazia Muhammad Muzammil versus State of Karnataka. So, Lordship, para 14 I'll read. In fairness, I must say I did not read that judgment because the relevant part is now quoted here. The purpose of any probation is to ensure that before the employee attains the status of confirmed regular employee, he should satisfactorily perform his duties and functions to enable the authorities to pass appropriate orders. In other words, the scheme of probation is to judge the ability, suitability, and performance of an officer under probation. 15. Similarly, in Rajesh Kumar Srivastava versus State of Jharkhand, it opined, a person is placed on probation so as to enable the employer to adjudge his suitability for continuation in the service and also for confirmation of service. So two things now lordships have held in this judgment. Not just suitability, but also whether we confirm or we don't. And confirmation under the rules is a condition precedent. There are various criteria for adjudging the suitability of a person to hold the post on permanent basis and by way of confirmation. At that stage and during the period of probation, the action and activities of the probationer appellant are generally under scrutiny, and on the basis of his overall performance, a decision is generally taken as to whether his services should be continued and he should be confirmed or he should be released from service. Para 16. It is thus clear that the entire objective of probation is to provide the employer an opportunity to evaluate the probationer's performance and test his suitability for a particular post. Such an exercise is a necessary part of the process of recruitment and must not be treated lightly. This is what lordships are holding. Written tests and interviews are only attempts. Please mark lordship because they have relied on it. Written tests and interviews are only attempts to predict a candidate's suitability of success at a particular job. The true test of suitability is actual performance of duties, which can only be applied after the candidate joins and starts working. Such an exercise, para 17, undoubtedly is subjective. Therefore, respondent one's contention that a confirmation of probationers must be based only on objective material is far-fetched. Although quantitative parameters are ostensibly fair, but they by themselves are imperfect indicators for future performance. Now, lordship, I'm pausing. The width of that assessment is not just objective. The test you may pass, the departmental exams you may pass, the training you may pass, there is an objective criteria. It's part of the process of evaluation. But at the second part, which lordships are holding, is that ultimately there is the subjective part. And our submission would be, lordship, most humbly, that the purpose of probation is fully served in the case of each one of the appellants. Because the issue under consideration of the government while taking that decision is the suitability of such a person with such grave allegations with regard to their entry into the service, in terms of the detailed investigation, the findings of the forensic lab, and lordship, this is not as a criminal code where it has to be beyond reasonable doubt. At the government's level, the qualitative assessment is equally important. And this is additional to the argument that they were only probationers and under the rules that power to discharge them existed completely. If I may continue, lordship. Qualitative assessment and a holistic analysis of non-quantifiable factors are indeed necessary. That's why I pause. Non-quantifiable factors. Merely because respondent one's ACRs were consistently marked good, it cannot be a ground to bestow him with a right to continue in service. Para 18. Furthermore, there is a subtle yet fundamental difference between termination of a probationer and that of a confirmed employee. Although it is undisputed that the state cannot act arbitrarily in either case, yet there has to be a difference in judicial approach between the two. Whereas in the case of a confirmed employee, the scope of judicial interference would be more expansive given the protection of Article 311 of the Constitution or the service rules, but such may not be true in the case of probationers who are denuded of such protections while working on a trial basis. Para 19, probationers have no indefeasible right to continue in employment until confirmed. So that is where the line is. Once confirmed, an indefeasible right comes. Article 311 and its entirety, its scope will become applicable. It is only in a very limited, and now they will quote on Parshottam Lal Dhingra, it is only in a very limited category of cases that such probationers can seek protection under the principles of natural justice, say when they are removed in a manner which prejudices their future prospects in alternative fields or casts aspersions on their character or violates their constitutional rights. In such cases of stigmatic removal only, that a reasonable opportunity of hearing is a sine qua non. Otherwise not. Way back in Parshottam Lal Dhingra, a constitution bench opined, in short, if the termination is founded on the right flowing from the contract or the service rules, then prima facie, the termination is not a punishment and carries with it no evil consequences. So Article 311 is not attracted. But even if the government has, by contract or under the rules, the right to terminate the employee without going through the procedure prescribed for inflicting the punishment for dismissal or removal or reduction in land, the government may nevertheless choose to punish the servant, and if termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and the requirements of 311. But Lordship, the point to be made is that first, in the case of the probationer, it's a very, very narrow and limited applicability as compared to a confirmed employee. There is no quarrel with that principle. And second, the onus of that will shift onto the appellant, not the state, which is what they have to endeavor to show. But let us see what further the court holds. Now, Lordship, para 20 is interesting. They quote the order of termination. The Rajasthan High Court, Jodhpur, after examining all the relevant records, has been of the opinion that Shri Ved Priya has not made sufficient use of his opportunity, and otherwise also, please mark, Lordship, the word failed to give satisfaction as a probationer in the Rajasthan judiciary. And Lordship, respectfully, a line of argument can easily come that the use of the word failed is stigmatic. And it's an argument that, in fairness, it would be taken and may have been taken in his case too. That you've even used the word failed, which is casting a direct aspersion. Now let's see what the Honorable Supreme Court holds. It is explicit from these contents that neither any specific misconduct has been attributed to Respondent 1, nor any allegation made. The order is based upon overall assessment of the performance of the Respondent 1 during the period of probation, which was not found satisfactory. Such an inference which can be a valid foundation. Now, Lordship, because these words come into play, foundation, motive. But let's see how the court is looking at it. Such an inference which can be a valid foundation to dispense with the services of a probationer does not warrant holding of an inquiry in terms of Article 311 of the Constitution. It is thus not true on the part of Respondent 1 to allege that it was a case of indictment following allegations of corruption against him. Now, Lordship, let's come to para 23 where the vigilance report is dealt. The vigilance report suggests that one of the factors which prompted the administrative committee or the full court to not confirm Respondent 1 was his actions granting bail. Now, Lordship, this paragraph broadly says there is no allegation that he took a bribe. There's no allegation. But the very fact that he was granting bail in NDPS cases against the law was enough to arrive at the logical conclusion that this is something that we need to look at. Now, Lordship, this is at a far lower foot. There is no here there is material that points directly to them. And how can we not take that subjective view in the interest of the office?
That is the distinctive point. You see here, in this case, the argument which is being built up is that in the order of termination, also you refer to suspension. And therefore, anybody can call for the records and they will find out that he's been suspended because of the allegations contained. So that is in contradiction to here, because here it says that you have failed to live to that expectation. And therefore,
may I, Lordship, then for a minute, at this point, show any discharge order. I can read it only, it's a 3-line order. We read it. And Lordship is basically identical in the vast majority of cases. the governor of Assam, in exercise of powers conferred under Rule 20C of the Assam Civil Service Rules, I'm reading one order, Lordship, 1998, is pleased to discharge so and so ACS, bracket, probationer, circle officer at this post, bracket, under suspension from service with immediate effect. Now, Lordship, it is a fact, and I will show to that effect also. Even if you put even if the word FIR was to come, it is not stigmatic, because that is a fact. And now, Lordship, the second part which has to be placed under consideration is under the same rules. Within 48 hours, there's an automatic suspension that flows with arrest. So therefore, the state is only following the rules. So if there is an arrest which takes place, within 48 hours, you have to be suspended. And are they probationers? Yes. Are they discharged under the rules? Yes. Are they confirmed? No. Can any one of them show that there is an order of confirmation? No. Can they argue deemed confirmation? It's against the settled law. There is no argument of deemed confirmation. That's the argument line how we build it, Lordship, in one sentence. Para 24, Lordship. Now, that may not apply to my facts, Lordship, but I wish to show it completely because this is the latest judgment, so I must show, Lordship. I don't want an allegation that I was trying to leave a point here or there, because ultimately every judgment is in its facts, Lordship. Even otherwise, it may not be true that just because there existed on record some allegations of extraneous considerations that the High Court was precluded from terminating the services of Respondent 1 in a simpliciter manner while he was on probation. The unsatisfactory performance of a probationer and resultant dispensation of service at the end of the probation period may not necessarily be impacted by the fact that meanwhile there were some complaints attributing specific misconduct, malfeasance or misbehavior to the probationer. If the genesis of the order of termination of service lies in a specific act of misconduct, regardless of overall satisfactory performance of the duties during the probation period, the court will be well within its reach to unmask the hidden cause and hold that the simpliciter order of termination is in fact intending to punish the probationer without establishing the charges of way of a inquiry. That is that narrow window which I was talking about, Lordship, in terms of foundation and motive, which will also get covered when I distinguish it. The second part being, Lordship, within this judgment only, the scope of the jurisdiction is also said that please, which is what they use the word cautiously, and they say it's not an appellate proceeding. Now, when I go later, Lordship, I will show a judgment that if it falls into, that's an interesting judgment of the full court of Patna High Court. Of course, that was a 2-to-1 ratio. But why I'm relying on it? Because this has been further relied upon. It's an 87 judgment by the Honorable Supreme Court much later. So therefore, the Supreme Court has broadly relied on it. And that, Lordship, may perhaps be very interesting language to read because it's penned in a very, very nice way. That is of Justice Sandawalia, who's now, of course, Chief Justice of Himachal High Court. But that one was one which took me back to, as I call, the old school judgments where, you know, a lot of thought was given on the language also. I'm sorry, I stand corrected. This is the father of Justice Sandawalia, who's now at this. That's absolutely right. The senior Justice Sandawalia. So, Lordship, conclusion, para 27. In light of the above discussion, the appeals are allowed and it was set aside, Lordship. So, Lordship, to conclude the argument, I have broadly said everything, Lordship, multiple times. But I am establishing through the settled law, through the decades from 1964 right up to 2021, this is the position with regard to probationers. This is the position with regard to deemed confirmation. And Lordship, before I close that, I am now must in my duty satisfy Lordship on those facts related to one petition.
Triple one writ appeal.
Writ 111.
Kavita Das.
Kavita Das. Court Master, sir. Writ 111. Kavita Das. Writ appeal 111. 3 pages I need to show, Lordship. And once Lordship has the file, may I request Lordship to come to page 46, which is the document they are relying on. This is an APS case. The Lordship remembers the APS rules. Probation 2 years, extendable with an open end. And then there is a separate rule 17, under which there's a confirmation. Now, they relied upon 2 documents, Lordship. I'm seeing the documents and I will show what is our response. I have already dealt with the legal propositions while I showed this line of judgments. So Lordship may just come to page 46. Has Lordship got that? Which is the notification of 15th September 2017. September 2017. Lordship, everybody's names are there. I don't need to point that out. Now, Lordship may come to the very end of this order. Page 48. And if I recall, Lordship's query was related to this sentence at the end of page 48 and then the governor's notification of 2000. The above posting of APS junior grade DR 2015 batch have completed probationary period of 2 years. Now, Lordship may please mark, it's the completion of the tranche of probationary period of 2 years. First part. Then, Lordship, I'm reading it slowly. And the second part, it's a factual statement. And are exempted from mandatory posting in battalions for a period of 4 months as per the OM so-and-so dated 30/8/2004. Now, the purpose of the sentence comes, as their services are urgently required, it should be required, in the field and in the specialized agencies. Which are those agencies? CID, Border, Vigilance, CM's Vigilance, STF, SB, due to shortage of officers. So now there is an expedient situation. They are posted. And as I read it, Lordship, the following 3 things come from this reading. First, probation is completed of 2 years, factual. Second, there is nothing that can be read either ways on its extension. However, the line of judgment say, if the probation period is on and it can be extended, you can only be deemed as being extended in probation, not use it as a confirmation, because the settled law is the condition precedent that exists in the rule, which is calling for a specific act of satisfaction, an order of the governor, is not done. That is the settled law. Let's see further, Lordship. Under Rule 17, this does not say there is a dispensing of the statutory ambit and requirement under Rule 17, satisfaction, which calls for satisfaction. There is nothing in this order that deals with it. Now let us, Lordship, they are relying on a 2004 OM of the Honorable Governor. So let us see that. That is, Lordship, at page 190 of the same paper book. Lordship, 190. 190. So Lordship may mark the date. This is the 30th August 2004 office memorandum, which is referred in page, Lordship, 46. And if you may read it, in partial modification of this department's OM number so-and-so of 2003. So there is a 2003 OM. The period of compulsory posting in respect of newly recruited APSC junior grade officers in armed police battalions after completion of prescribed probation period of 2 years is reduced from 1 year to 4 months with immediate effect. Now, Lordship, this respectfully and in my humble submission, Lordship, is only about the posting after completion of the tranche of 2 years probation in the battalion, and that being reduced from 1 year to 4 months. This again has nothing to do with the requirement of confirmation. This is not overriding the rules, dispensing with the rules. In this case, specifically Rule 17.
Please explain again.
Lordship, 4 points. The OM of 2004, Lordship,
Yes.
merely is about the reduction of a particular posting after completion of 2 years of probation. It's only on that. With regard to that posting in the battalion, that you now need to be posted in a battalion. Originally, as per the 2003 OM, which is how it explains, it was 1 year. This is reduced to 4 months. That's the clear reading as it is there. Now, what are the legal propositions to counter the argument? This has nothing to do with confirmation.
Okay.
This has nothing to do with Rule 17.
Satisfaction.
Number 3, Lordship.
Just a moment.
Of course, Lordship. I'm so sorry about.
No, it's okay.
Statutory Rule 17 भी override कर देगा. This is what we are seeking, a light confirmation. By reading into it, it's just all that's it. This point was rebutted before the single judge. सिर्फ पैरामाइज दिखा दीजिएगा. हमारे पैरामाइज जो सिंगल जज में लाइक फाइल हुआ था वो उसके बाद दिखा देंगे. So answer, yes, then answer, yes, then also, now also the answer. Let's go with that. Single judge we know.
Lordship. Now, the next point, Lordship, I was submitting for Lordship's consideration is that this is an OM. It cannot override a statutory rule. I'm not repeating the earlier arguments of deemed confirmation. It cannot. That because the statutory rules are a subordinate legislation. And this is an OM, which is for a specific purpose, has nothing to do. This argument, Lordship, is in effect the argument of deemed confirmation, which is what is being done. Through this OM, the argument of deemed confirmation is being brought. The settled law on deemed confirmation I've already placed before Lordship. Now, this argument was placed before the learned single judge, and we responded to this argument before the learned single judge as part of the response. And just for record, Lordship, that is at page 185 of this paper book. That is para 19, Lordship. I can read it also, it's one para, but the fact is, the argument was taken, the argument was responded, and the argument hasn't found force. Because these are the same arguments, Lordship. Lordship, in fairness, as we say, sometimes our ears catch it. So an argument which fairly falls is that has it been dealt with? That is the counter argument, that you've raised an argument, you've dealt it. Lordship, in a recent, we had the occasion, and I can bring that judgment on record, Lordship, if required. We had a very interesting situation that a big appeal went before the learned Honorable Supreme Court, very big paper book with a lot of things in it. And that, Lordship, then the Supreme Court rejected And when we were back at the High Court, we relied on a judgment to basically say that all was placed before the court. Once you argue the point, it is deemed to have been argued because it's part of the record. The argument can't be said that there was a specific line in that which was missing. But I can answer that also, Lordship. Para 19, if just as a record and closure of this argument, Lordship, the contents of para so-and-so of the writ petition are incorrect, misconceived and denied. The submissions made in herein above are respectfully reiterated. The reference to the notifications of 15/9/2017 is not just misplaced, but also misconceived, misleading and denied. The notifications dated 15/9/2017 are not orders of confirmation in service of the petitioner. The said notifications are only with reference to OM dated 30/8/2004 of the Home Department, which provides that for persons who have completed 2 years of probation, the compulsory period of posting in the armed police battalions is reduced from 1 year to 4 months. The petitioner may have completed 2 years of probation, but that does not result in any deemed confirmation in service, for which a specific order is required on the satisfaction of the Honorable Governor as mandated by the statutory rules. No such specific order for confirmation on fulfillment of the conditions as stipulated by the statutory rules have been issued in the present case, and the petitioner was continuing to serve on probation on the date of the issuance of the discharge orders. All contentions to the contrary are incorrect, misconceived, unsustainable in law, deserving rejection by orders of this Honorable Court. So in conclusion, Lordship, of this leg of arguments, through these lines of judgments from the Constitution bench right up to Durga Bhai and finally, Lordship, Vedpriya, the proposition that is established that there is no concept of deemed confirmation. When the rules, and this has stood the test of time over a fairly large number of decades, Lordship. That's one. There is also no room for doubt that each one of the appellants were only probationers on the date of their discharge. There is no confirmation order in any case. Now, Lordship, I will shift and start on a line of judgments, Lordship, vis-a-vis the non-applicability of Article 311 in the context of a tainted entry. Eventually, Lordship, so what Lordship, well, this is now basically over the next 12-14 judgments that I would be taking you, Lordship, through and Ladyship through between today, tomorrow. They will deal with sub-propositions in terms of tainted entry, then P&J will get covered, then 311 will get covered. They are all part of that entire sweep, Lordship. So, Lordship, this is a judgment. If you have a copy, share it with them. They can then photocopy. I think we can get a Banali, they can coordinate between themselves. We have an extra copy, Lordship, it always helps counsels. So, Lordship, where is my that file? It has the... Lordship, I am now on the proposition that where the appointment, as is written on the head note, Lordship, right at the top, where the appointment has been secured through illegal means or the appointee was not qualified at the time of appointment, such appointment is void ab initio, and consequently no violation of principles of natural justice can be claimed. And again, Lordship will note that from 1994, I'll be taking Lordship, which the last judgment is of 2022. The line is consistent, and Lordship, these judgments rely finally, the line of judgments falls onto Krishna Yadav, falls onto O Chakradhar, Shama Pardi, etc. Lordship, the second thing I must make clear, that while the facts are different, there is a similarity. And I must clarify this before I start reading the judgments, Lordship. The settled law which will emerge, and it's the consistent law which has stood the test of time, is the attempt must be to first see if you can segregate the grain from the chaff or the tainted from the non-tainted. This is the first attempt. Only if that exercise cannot be done and the entire examination process is so fouled that it goes to the root of the matter, the fraud, then you scrap the entire process. Now, several of these judgments have dealt with very pervasive taints in terms of the whole examination process being tainted. So in some of them, there has been removal of the entire examination, cancellation. But the principles that are established are reiterated, and in the final judgments, I will come back to Amarveer, Indrapreet primarily, because that's the Supreme Court, which is also considered within this line of judgments. So therefore, Lordship, Joginder and these become important, and they are covered. So Lordship, we'll start with Krishna Yadav, which was the first judgment.
We'll also be required to deal with the submissions of Mr. Mishra, where he has referred to the citations relied on by the learned single judge and says that it was misread and the principles were missing.
I'm reading those judgments. Then I will leave it to Lordship's. I will, because my entire argument, Lordship, to answer that in one sweep, if Lordship would permit me, is to say that the learned single judge has correctly appreciated the law as settled by the Honorable Supreme Court.
Okay.
Which is, that's why I said Lordship. And I'm therefore placing the same judgments before Lordship with further extensions of how they have continued up to the latest. So it becomes possible for Lordship to see whether that is true or not. And Lordship 2021, Sachin Kumar, which will be the judgment I'll come to later, of Justice Chandrachud, has dealt with this entire law, including naming all these very judgments. So Lordship, we will, incidentally, Lordship, Sachin Kumar, interestingly, deals also with the judgments relied upon by my learned senior colleague, Mr. D.K. Mishra. Because the line of judgments remains the same. We are professing our arguments around those judgments. Lordship, Krishna Yadav and others versus State of Haryana, 1994. This, Lordship, will take me some reading because there are several things to be shown in it. But broadly, Lordship, the facts. They were taxation inspectors selected by the Subordinate Selection Board. And Lordship, the consideration before the court was the validity of the selection. Now, Lordship, the appellants who came before the court were the unsuccessful candidates. So, I'm just giving the sweep of the... In this, Lordship, the Haryana, it was a Haryana examination, Lordship, and fictitious roll numbers were given. There was a rechecking. These are all the facts. I'm, Lordship, saving time because of that pressure. But basically, I'm reading, I'm broadly giving you the facts from para 1 to para number 8. These are the basic facts. What finally happened, Lordship, is that the final selected officers, no medical test was done. There was nepotism, and the answer sheets were also disappeared. Because when questions started being asked, the answer sheets were disappeared. The High Court upheld the appointments at the first stage. The unsuccessful candidates came to the Supreme Court, and that, Lordship, starts from para 9, which is where I'll start reading from. For reasons best known, the original record, including the answer sheets, were destroyed on 27th of December 1989. This is attacked by the appellant as an attempt to cover up the illegalities committed by the board. Primarily on these allegations, several writ petitions were filed before the Honorable High Court. The facts as obtainable in so and so were taken for consideration. The High Court was of the opinion that in view of the fact that all answer sheets and the tabulation sheets have been destroyed, the allegations of the petitioners therein could not be ascertained. So they dismissed it. So this was what happened, para 11. Aggrieved by the judgments dated so and so passed by the Honorable High Court, Krishna Yadav and Ashok Kumar, the appellants herein, have preferred the civil appeals. Para 12. In view of the serious allegations made, particularly the destruction of records alleged to be for the want of space, this court passed orders on 9/10/91 directing the government of Haryana to refer the matter to the CBI for investigation and to complete investigation within 3 months. The time for completing the investigation was extended. The Superintendent of Police of CBI Chandigarh submitted a detailed report. We record the same. Lordship may now note, no trial, no show cause notice, refer to the CBI or the police. In our case, it's the police. There is no TP. In this particular case, they rely on that report and the findings of the report, which is basically the investigation. In our case, it's a police report. Now, Lordship, let us see the contentions of both sides. Para 13. The argument on behalf of the appellants addressed by so and so may be summarized thus. This is a clear case in which various acts of nepotism and favoritism have been committed. The whole selection is arbitrary. Very conveniently, destruction of reports is pleaded. Unfortunately, the High Court has not given much attention to the allegations and examined the veracity of these allegations. When the respondents sought cover up under the destruction of records, the plea has come to be accepted. As a result, the appellant's allegations could not be verified. Please mark, Lordship. This is hardly the way to render justice. This is an argument. Fortunately, before this court, there is the report of the CBI. This will clearly establish how there is a concerted fraud. Persons in authority have played truant with the fate of many candidates. There are overwritings and interpolations in the selection list. People who have did not attend the interview have been awarded marks. Forgery has been committed. Hence, the entire selection will have to be set aside. This is what's argued. So, Lordship, the argument here is on interpolations, etc. Cash recovered, not recovered, that's not an argument. Para 14, Lordship. In opposition to this, Mr. So-and-so learned counsel for the selected candidates argued that they are not in any manner responsible for the alleged fraud or nepotism. Therefore, the sins of others should not be visited upon the selectees. Even otherwise, as of today, they have rendered service for nearly 4 years. If they are thrown out of the job now, they will be on the streets. It will work great hardship. Therefore, the selection may be spared and the authorities concerned may be pulled up for the lapses. 15. It is not possible for this court to enter into the factual domain and decide the case one way or the other. We have already mentioned about the report of the CBI. We will only go by that as the report commends itself to acceptance. Lordship, when we see the learned single judge's judgment, he speaks about the thorough investigation which has been assailed in the arguments of the appellants. So here the court is relying also on an investigation and says that we will only go by that as the report commends itself to acceptance. In our considered opinion, the CBI has done a commendable job and has not failed to call a spade without shielding anyone concerned, including a minister. Now, Lordship, I won't read the report. Lordship may turn the page. I will just request Lordship to see the various headings, conclusions. So, Lordship, on the next page, the conclusion after the first paragraph is no interview. Just that. Then, Lordship, the next conclusion on the second paragraph is fake interview at the end of the paragraph, Lordship. The third is ghost interview. Then, Lordship may turn the page. Fabrication of records. Why I'm showing this, Lordship? Because these are the similar kind of findings in some of the cases, which will apply in our sort of facts also. Lordship may turn the page to 9. Right at the bottom of the page, before the last paragraph, forgery. Page 10, Lordship. Action at the behest of higher-ups. Next is ministerial conclusion, which does not apply here. Next one, Lordship, is favoritism. The above, and I'm reading now, Lordship. The above extracts unmistakably establish the misdeeds of the board. Having regard to all of the above, the irresistible conclusion is fraud has reached its crescendo. Deeds as foul as these are inconceivable, much less could be perpetuated. Then Lordships have been pleased to quote Shakespeare. Para 17, Lordship. I must also admit, Lordship, it goes above my head because I didn't study Shakespeare. That's an honest confession. Lordship, para 17. It may not be too much to draw an inference.
But without Shakespeare, it's very difficult to clear up a subject of English.
Lordship, then I have been fortunate. But then, Lordship, we have Lord Denning and others also. Now, Lordship, para 17 onwards makes very interesting read. Please see what Lordships have held, Lordship. It may not be too much to draw an inference. Lordship, we spoke about subjective satisfaction. Here we are talking about inference. that all these were motivated by extraneous considerations. Otherwise, how does one account for selection without interview, fake and ghost interviews, tampering with the final records, fabricating documents, forgery? Each of this would attract the penal provisions of the Indian Penal Code. They have been done with impunity. Now let's go, Lordship. Para 18. The story does not end here. From out of the selection list, secret communications have been sent to the candidates. Selections have been made without medical test or verification. Now, the secret communications, we can say in this case, those candidates have been contacted, given opportunities, which is what the investigation points to. 19. It is highly regrettable that the holders of public office, so this is the driving factor always, Lordship. It is highly regrettable that the holders of public office, both big and small, have forgotten the offices entrusted to them are, please mark, Lordship, the use of the word sacred trust. That is why we talk about public interest and we talk about the trust of the public. Such offices are meant for use and not abuse. From a minister to a menial, everyone has been dishonest to gain undue advantage. The whole examination and interview have turned out to be a farcical, exhibiting base character of those who have been responsible for this sordid episode. It shocks our conscience to come across such a systemic fraud. It is somewhat surprising that the High Court should have taken the path of least resistance, stating in view of the destruction of records that it is helpless. It should have helped itself. Law is not that powerless. Now let's see what Lordships hold. In the above circumstances, what do? The only proper course open to us is to set aside the entire selection. The plea was made that innocent candidates should not be penalized for the misdeed of others. We are unable to accept this argument. When the entire selection is stinking, conceived in fraud and delivered in deceit, individual innocence has no place, as fraud unravels everything. So this is extreme case. To put it in other words, the entire selection is arbitrary. It is that which is faulted and not the individual candidates. Accordingly, we hereby set aside the selection of the taxation inspectors. Now, Lordship may read. The effect of setting aside the selection would mean that the appointments held by these 96 candidates, including the respondents, will have no right to go to the office. And please mark the next word. Normally speaking, we should require to disgorge them the benefit of these ill-gotten gains. That means they will have to repay the entire salary and perks which they have received from the said office. But here we will show a streak of sympathy. For more than 4 years, they were enjoying the benefit of office. The proper lesson would be learned by them if their appointments are set aside, teaching them that dishonesty could never pay. All this Lordships have done on the basis of a CBI report, no trial, no DP Lordship, no show cause notice, no principles of natural justice. And Lordships have also said that if one has occupied a public office, the argument can be taken or the action may be considered of disgorging that person of the amounts that they received as part of an office they were not entitled. Now Lordship may just see page 12, bottom second last paragraph. Which is Roman 12, Lordship. Since we have accepted the CBI report, we direct that necessary prosecutions be launched early against all concerned, whoever high or low they may be in the hierarchy of officialdom. The state government will do well to grant the necessary sanctions if they so required without due delay. Now, Lordship, this has been done in our case way ahead. It didn't require a court order to do so. I'm just pointing that this was a case where it was not done. The court intervened that this is the necessary steps. In our case, the reliance is from day one on the investigation. Here an investigation had to be ordered. And this formed the satisfaction, Lordship. We may go to the next judgment, Lordship.
We'll continue tomorrow.
One page? I was just trying.
One even.
It's only one page. I am only trying to, Lordship, persuade Lordship to be a little more indulgent towards me, Lordship. In time, in judgment, we will leave it to Lordship completely. But in time, I'm seeking that indulgence. If tomorrow Lordship may be so pleased to consider my request. I do have a lot more to read. Subject to what Lordship and Ladyship can work out, because I know there's a separate bench also. I also have, Lordship, a personal difficulty, which I must in honesty share, is that on the 11th, I'm scheduled to fly several thousand miles away. And the time zone difference may become an issue. So I'm very keen to finish my course of argument. I'm taking my father, mother, everyone out. So it's something, if it was individual, it's easy to do it. But with the whole family, it may become a little onerous. That's why I was hoping that if Lordship would be indulgent tomorrow and day after, I can try to finish mine and give them an opportunity to start on Monday. Lordship also has to write a judgment.
You should have booked a, what do you call all those
private
what is called, no. What are they called? Cruise. You could have taken everybody.
So Lordship, if Lordship has a black tongue, I will wish me many more things, because actually we booked a cruise. It is actually booked a cruise. So, Lordship, in fairness, my dad is 83, mom is 79. So he told me a few months ago that I want to do one last cruise. I used to always send them on cruises because the bedroom travels with you. It's very difficult as you get older to travel. It really came very heavy on me. What do you mean last cruise? I'll give you as many cruises you want. Then I told my mother and father, but at your age, I worry. In India, if something goes wrong, God forbid, we are well equipped to take care, but globally. So they say, when will we travel otherwise? So that has now become a priority for me. As much as they say, wherever they want, let's just travel.
Good. This is also for the appellants are present. Just indicate your names.
Today, Lordship, a lot of my colleagues from the bar are here.
The submissions of Mr. N. Kohli and Senior Counsel assisted by so-and-so remains inconclusive. List again on. List on so-and-so as part of that.
Lordship, 12 o'clock, if I may, Lordship, once again, is request for Lordship.
Make a try, because we
So
don't.
what I'll do,
all
Lordship,
this-
I will come here at 12, of course, and I'll see if Lordship can manage even half an hour, 45 minutes.
Because this, that bench also has a lot of huge pressure.
I'm aware, Lordship, and I'm genuinely saying it, I'm aware, and that's why. But I'll, Lordship, make myself available just in case it is possible.
In a very difficult spot, because we are taking up those matters, APSC matters for day-to-day hearing. We are rising for these benches. So adjournment is not welcome.
From last 2 to 3 days, Lordship, he is not feeling well, Lordship.
Both of you agree to a date?
Lordship, actually, we are here for long detention. That is, and I'm
You
upset.
understand, but if somebody is not well, we'll take it up on Monday, no adjournment.
Lordship, can it be on Tuesday, Lordship? Tuesday.
Tuesday, we have partnered matters.
Yeah.
No. Both sides are represented. Miss
M. Deka.
M. Deka, Learned Counsel, appearing on behalf of Mr. S.C. Kyal, Learned Standing Counsel for the NCB, submits that his last 2 days is not keeping well. Therefore, she prays for adjournment. Next paragraph. The matter is reluctantly adjourned today. So, however, the matter would not be adjourned with the next date of listing. Next list on 9/6/2025. Because we are adjourning those hearing matters because of these matters.